Yes.
May I be permitted to mention one matter, motor accident claim matter for
Yes.
exclusion in the list? One motor accident claim appeal for substitution.
Yes.
Second appeal.
Second appeal, is it ready for hearing matter? So just wait this week.
Kindly mention.
No, may mention next week. Any hearing matter in connection with second appeal or first miscellaneous appeal, please mention next week.
This is an application.
Yes.
This is an application, my lord, urgencies list. On 17 November, date has been fixed in the small causes for execution of the decree. There was an interim order.
Any application?
Yes.
Yes. With regard to any application in connection with appeal, please give the slips.
Mentioning three claim matters.
Applications. Yes.
Mentioning three claim matters.
Yes. Give the slip. Claim case?
Motor accident claim case.
Yes.
Motor accident claim.
Any application in connection with second appeal, first miscellaneous appeal, please hand over the slip.
Change of determinants on this
Yes.
matter. Last week they appeared to be another bench.
No. What matter?
Had the other side lawsuit.
So mention next week. Just wait for this week.
But also, this is my suit, and this was we had mentioned just before the vacation. It was supposed to come today, or
No, this is what appellate side matter.
Original side matter, my lord.
Original side matter. Is it a part heard matter?
Yes, it's the part heard
So
matter,
it
my
will be
lord.
taken up on Fridays.
The thing is that last week I had mentioned I am one of the
Anyway,
defendants, my lord.
The original side officer is here.
It
Anyway.
was supposed to appear this week today because my lord used to take Tuesdays and
Wait,
this
see,
chamber.
no.
I understand.
If it is a part heard
Part heard
matter,
matter,
it
it is
will
a
be
part heard
taken up
matter.
on Friday.
Very
It will appear on Friday.
Very well.
obliged, your lordship.
Grateful, my lord.
That's my permitted to mention for inclusions in the list.
Inclusion under what? Motor accident claim.
Stay applications,
Stay application with regard to?
claim case, model.
Yes, give the slip.
Item number one. On my lord, this is actually the second appeal of 2026.
2000?
2026.
2006. Okay. So this court does not have determination. Yes, record an order. As this court does not have determination to hear this matter, the matter stands released from the list. The matter may be placed before the regular bench. Not today.
Number three for judgment.
No, it's at 2 p.m.
Sorry. Number four. For my lord, I am for the petition. But this is the expedient hearing, my lord. Appeal was my lord there.
This is an assigned matter.
Yes. 2007, my lord.
Okay.
2017, my lord.
No. How old is the suit? 2013.
Yes.
Oh, this is the title appeal
Title appeal, my lord.
of 2013.
Yes. Time to time, they are taking adjournment. Therefore, my lord.
When is the next date?
Next date, my lord, 11th, 17 November.
Yes, record an order. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. This application is moved with a prayer for a direction upon the learned appellate court, being additional district judge, fast track court, Baruipur, district South 24 Parganas, to hear out the title appeal number 2 of 2013. Stop. It is submitted by the learned advocate that the said appeal is pending for a long period and is not disposed, for which the appellant petitioner is suffering prejudice. Stop. In the facts and circumstances, no fruitful purpose will be served by directing issuance of notice upon the opposite parties. Stop. This application thus stands disposed with a request upon learned additional district judge fast track court, Baruipur's district South 24 Parganas to hear out the said title appeal number 2 of 2013 expeditiously and preferably within a period of 5 weeks from the next date fixed. This application stands disposed.
Five.
Milord, in item 5 and 6, Milord, Mrs. Paul is appearing on behalf of the appellant, Milord. She is in
I'm passing it over.
Milord, she has not come today, Lord. She will kindly not make it.
Okay,
either
not today.
or not this week, Milord. Whatever, my Lord, please.
Making it not today?
Not today.
I am for the respondent, my lord. My lord, Mr. Sucharita Paul is appearing for the claimant, appellant, my lord.
Milord,
Yes,
that's
same.
the
Same also not today.
Not today, Milord, and 8 as well, Milord.
Yes, my lord.
8 also.
Yes.
8 to
8, I am appealing on the day.
Okay, not today.
Not today, my lord, not today.
Grateful to your Lordship, Milord.
number 9.
Milord, item number 9, I am for the appellant insurer.
Yes.
Mr. Romit Ranjan Roy is for the respondent. Milord, he requested me to prepare for your Lordship to make it not this week, Milord. I am for the appellant.
Not this week.
Not this week. Milord, he requested me, Milord.
Okay, not this week.
Grateful to your Lordship.
Number 10.
But 10, my lord, I appear on behalf of the insurance company appellant. It's my appeal.
So the respondents have entered appearance.
Yes,
Paper books have been filed.
the last occasion, actually, the matter came up before Honorable Justice Anona Bandyopadhyay, when our ladyship had directed them to obtain the certified copies because the records are here only for preparation of paper book. They have not yet done. Kindly allow them.
So
to
how much time do you require to file the paper books?
My lord, unless and until those documents are available
No,
from
no,
the
that,
department.
no. How much time do you require?
My lord, as soon as we get some documents from the department.
Yes, record and order. Learned advocates for the parties are present. As the trial court records have come, the learned advocate appearing for the respondent is granted liberty to file the paper books on or before 2/12/2025. Let the matter appear on 2/12/2025. The records be sent to the department to enable the learned advocate to obtain the certified copies of the relevant documents. 2/12/2025 for hearing.
Milord, item 11 was called on by your Lordship yesterday. It was made not this week. Perhaps it is appearing by mistake. It's not mentioned here.
Item 11 was made not this week.
Not yesterday, Milord, it was
Okay, item number 11 not this week.
made. God bless your Lordship.
Yes. We are for the appellant here.
Yes, item
Paper
12.
book already has been served.
Who is appearing for the opposite party?
Respondent is my learned friend. That is.
Okay, paper books have been filed.
He already has been.
Yes, record and order. Learned advocate for the appellant is present. Learned advocate submits that the paper books have been filed and served. Let this matter appear on 10/11/2025 for hearing. So learned advocate for the appellant is requested to intimate the other side advocate by notice.
Grateful.
13, my lord, I appear on behalf of the respondent insurance company, my lord. Just Saidur Rahman is appearing for the appellant.
Not today.
I think it's not today.
Milord, this is an insurance appeal. Milord, it was taken up yesterday as well. Mr. Ali Imam Shah, Milord, is for the respondent. Milord, in this case, I have secured the entire.
He has to come from Barwan probably.
My Lord knows him.
Yes,
Yes.
probably while I was posted in this Durgapur, he used to
Lordship.
appear
Lordship, yes.
in this MSCC matters.
My Lord. Milord, in any event, Milord.
No, whether his junior can do the matter, he must be having his junior here.
Milord, today, Milord, I have secured in terms of interim order, I have secured the entire compensation amount.
No, your stay application is disposed.
No, Milord, your lordship will kindly
So
dispose
it's
it.
not appearing in the list.
Huh?
Yes, what is your CAN number? CAN 1?
Can one, yes, Milord.
Yes, let CAN 1 of 2025. Let CAN 1 of 2025 appear in the list on 6/11/2025. Okay, intimate the other side, advocate.
Your lordship. Can one, yes. 6/11. Milord, can one, it is not reflected in the list, but it must be in the file.
না দেখে নিন, আমি তো বৃহস্পতিবারে রেখেছি, তা যদি যদি না পাওয়া যায় আবার থাকবে, শুক্রবারে
Milord,
থাকবে।
interim order was passed, can one has to be in the file. Perhaps, Milord, even then, Milord, subject to correction.
দেখুন আছে কিনা ওটা।
Because, Milord, interim order was passed.
Yes, had other side appeared, I could have treated that in the days list.
হ্যাঁ
আছে, তাহলে থাকবে, বৃহস্পতিবারে থাকবে। Yes, on 6th it will appear.
lordship.
Intimate the other side.
My God.
হ্যাঁ। Okay, I'm just making it not today, okay? No, but না ওই ডাইরেকশনটা তো তাহলে থাকবে না, CAN 1টাকে ওটা তো
Yes, Milord, that is to be deleted.
এমনি দিয়ে দেবেন। আচ্ছা ঠিক আছে, তাহলে not today থাক।
Only not today, Milord.
Yes.
Number 15.
I'm for the appellant, my lord. হ্যাঁ, এটা কি করে এসেছে, যেটা যেটা আজকে আসার কথা ছিল সেটা আসেনি।
No, item number 15. So item 15 is due to appear today.
Another matter I mentioned yesterday, it was
Oh, item 15 is not this week.
not this week. Another matter did not appear.
Anyway, give the slip, it will appear.
Okay.
Number 16.
Milord, 16 is, Milord, insurer's appeal. Milord, interim stay was granted. I have secured the compensation
So
amount.
same, that
Milord-
CAN 1 is not appearing.
Milord, affidavit service is here. Milord, your lordship will
No,
kindly-
CAN 1 is not appearing. So how I will make it absolute? In the absence of the other side, how can I? Because if the other side is here, by consent, it can be treated in the days list.
Lordship.
Yes, record an order. Learned advocate for the appellant is present. আচ্ছা এটাকে ক্যানটা যদি থাকে তাহলে ক্যানটাকে দিয়ে দেবেন এখানে। ক্যানটা আছে কি?
হ্যাঁ থাকবে, interim stay তো ছিল, কেন থাকবে?
আচ্ছা, just I'm making it not today.
কি বলি এবার, আমি কাকে বলবো, আপনাদেরই দেখতে।
No, unless I direct whether they will list this CAN 1. Oh no, if it is here, it will be done.
Should be.
আচ্ছা তাহলে not today, just not today.
Item number 17.
Milord, 17 and 18, Milord, Mrs. Paul is there. She has not come today, Milord. Your lordship will kindly make these notes.
17 and 18, not today.
Not.
19.
Milord, 19. Milord, 19 can achi. Yes, Milord, your lordship, Milord, I have secured the compensation amount in view of the Milord interim order.
Oh, the scan is here.
Your lordship kindly make the Milord stay absolute.
Yes, they give
Milord,
me
may I
the-
file my affidavit service? Milord, let it be kept with the records. Milord, the deposit slip, Milord, for my lord's convenience, may I hand it over?
Yes, give this.
Lordship, দিয়ে দেবেন?
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the awarded sum in terms of order dated 2/8/2025, the judgment and order dated 13/2/2025 passed by learned Additional District Judge, Raghunathpur, Purulia, shall remain stayed till disposal of the appeal. The learned advocate for the appellant files affidavit of service. Let the same be kept with the record. The appellant shall take steps to serve notice of appeal through the department. Let this matter appear on 17/12/2025.
1712.
Can disposed.
Milord, item 20 can ache?
Yes, can is there.
Yes, Milord. Milord, in this case also, Milord, I was praying for Milord, the stay to be made absolute. I have made the deposit in terms of the interim order passed by this honorable court, Milord. Milord, may I just show my Lord, Milord, the deposit slip? Let the affidavit service be kept with the records. It is recorded.
Yes, record and order. Learned advocate for the appellant is present, as the appellant insurance company has made the deposit in terms of deposit of the awarded sum in terms of the order dated 2/8/2025. The judgment and order dated 30th April 2024 passed by learned Additional District Judge Diamond Harbour in MSC case number 179 of 2024 shall remain stayed till disposal of the appeal. Learned, the appellant shall take steps to serve notice upon the opposite parties through the department. Let this matter appear on 17/12/2025.
Grateful to your Lordship.
Let the affidavit of service filed by the appellant be kept with the record.
Obliged to my Lord.
Yes.
Milord, 21 is also similar application. Can, Milord, yes, can is there.
Can
Milord, I
is
was
not
praying for
here.
the
Can is
similar-
not here.
Milord, can is there, Milord, 21.
No, 21.
আছে কি
No.
ওটা? দেখুন তো ওটা উপরের না নিচেরটা?
যে ক্যানটা নট টুডে করছি ওটাকে কালকে থার্সডে দিয়ে দেবেন। Just I'm making it not today.
Lordship.
Let it appear on Thursday
My Lord.
with the can.
22 is the appeal by the Reliance General Insurance Company and 23 is my cross appeal.
23.
Well, matter may be disposed of. Only point involved in this.
So stay is there. Stay has already been made absolute.
Awarded amount.
So argue the matter.
Yes, yes.
My lord, this,
Well, let my learned friend, my lord, applicant, my lord, start part. আমি বলবো
my learned friend,
my lord,
other thing is also there in the
there are, my lord,
two
may
vehicles.
I submit, my lord, in article of this case, my lord. My lord, there are two vehicles involved. One, my lord, the two truck, one, my lord, the Tata Shark, and another is, my lord, truck. And both the trucks were
Tata
insured
Shark.
by both the insurance company. One is by the Reliance General Insurance Company and one is by the Royal Sundaram Insurance Company. Now, my lord, the claimants before your lordships are the, my lord, the wife and two sons. My lord, they paid compensation for the death of their bread earners, but that is the
Item
husband.
22. Item 22 is this
Cross.
the appeal. Item 22 is an
Is
appeal.
my appeal, my lord.
So let her submit first because she has preferred an appeal.
Yes.
My lord, as it was submitted by my learned friend, police constable has died in the
1326. Yes.
পেপারবুকটা দিন না জজ সাহেবকে
Then
paper
paper.
bookটা দিন, তা নাহলে
আছে তো নিচে ওই তো ওটাই পেপার বুক এইটাই
So it is a Comprehensive, both 1326 and COT 146.
I have, my lord, annexed, my lord, the court.
Both?
Both.
Yes. What are the facts of this case?
So the cases, my lord, one, the victim since deceased is a constable. He stopped a vehicle, Tata 407, in the middle of the road, and after that, another vehicle came and dashed that vehicle, which was stationary. It hit that constable and he died. That is the main fact of the case, and the claimants are the wife and
And two sons.
two sons of the constable victim since deceased. This is the case, and the vehicle which was stationary was insured by my learned friend's insurance company, Royal Sundaram, and another vehicle which dashed it from the backside was insured by my client, Reliance General Insurance Company. Now the tribunal has put the liability fully on my client, but I have preferred this appeal on the ground that there was no valid route permit and the pay and recover order may be given, because according to Swaran Singh, the learned, the entire awarded amount I will satisfy and I will recover from the owner of the vehicle. And another thing is, my lord, the professional tax was not deducted from the salary of the victim, and calculation has to be made accordingly. And these
Professional tax not deducted.
not deducted. And another thing is, the vehicle which was standing in the middle of the road was also responsible for this accident on contributory negligence to a certain percentage also. That is my case, my lord.
So entire liability is affixed on your client.
My lord, two
On
vehicles,
the vehicle which dashed, not
yes,
the vehicle which was standing
stationary. In fact, it was entirely the negligence of the constable who died. He cannot stop a vehicle in the middle of the road.
That's a different issue. Have you adduced any evidence on
No,
that
no, my
insurance
lord,
company?
that's why I do not come with that question.
So the award was also pay and recover.
No, no.
So it was not having route permit. But question is, was the vehicle owner examined? Vehicle owner not examined.
They do not appear. They do not appear before the court. In spite of the summons, my lord, will go through many cases. In almost all the cases, the owner do not appear in spite.
No,
of
examined
no,
by
not
you or
no,
whatever.
no, he was not examined.
Okay, the vehicle, yes.
He
According to you, there is contributory negligence.
yes, contributory negligence. Yes, composite negligence. Composite negligence. And the thing is, pay and recover due to invalid route permit. And
Invalid route permit. That means the permit expire how long? When?
No evidence.
No,
it
the
is-
permit which was seized.
it was not seized.
Permit was not seized.
কিচ্ছু নেই। Result is page 59 থেকে 64
A valid route permit is to be kept in the vehicle and it was not seized. Insurance and RC book and everything was seized,
But valid permit was not seized.
not seized.
Yes. That's all?
My lord.
My lord, may I submit, my lord, the facts of the case in addition to my learned fencing. My lord, there was an accident. My lord, accident took place on 12 January 2010, where a police constable died, my lord, due to involvement of the two vehicles. One vehicle is, my lord,
Yes, accident took place on?
accident took place on 12 January 2010.
Yes.
And my lord, and he died on 18 January 2010. My lord, after occurrence of the accident, he was brought to the hospital and after 8 days, my lord, he died on 18 January 2010. My lord, there are two offending vehicles. So far as my claim application, we proceeded. The claimants before your lordships are the wife of the deceased and sons of the deceased. And they paid for compensation to the tune of rupees 26 lakhs 33,000 with interest.
Compensation 26 lakh.
26 lakhs 33,000 while they paid for. But the tribunal awarded 29 lakhs 808.
No, the compensation claimed was 26 lakh and the compensation awarded was 29 lakh.
29 lakhs 808. 00808.
Okay. Anyway, enhanced the
And
compensation. So you are still aggrieved. In spite of that, you are still aggrieved. You claim 26 lakh. The amount awarded.
Your lordship is award by the Nakapa versus Buddha. Even pilot the claim amount
No,
is
tribunal is empowered to enhance.
tribunal pilot what assist pilot. Tribunal or the High Court is not powerless to grant the just compensation.
No, that is why the tribunal thought fit and granted 29 lakh 808.
But the tribunal did not consider pilot the make pilot the grounds which was decided by the constitutional bench of the Apex Court of India. That is, your lordship is aware that the National Insurance Company versus PROCEEDINGS, where the face of points were decided in the constitutional bench. One is the application.
The Sharola Verma's case is there.
Yes, Sharola Verma's case modified in the the PROCEEDINGS case. Sharola Verma's case decided 3 points. One point is the future prospect. But in the Sharola Verma, future prospect only confined to the government the employee, not the self-employed or the fixed wages effort. That was decided by the constitutional bench. Now, the second point decided the application of multiplier. In what manner the multiplier will be applicable. The second point. Third point is the deduction. Deduction if the number of claimants is 3, then 1/3.
The dependents.
Dependents. If the number of claimants are 4, deduction would be 1/4. And if the number of claimants 6, deduction would be 1/5. But in case of a bachelor, 50% be deducted on account of personal living expense. That is the deduction point. Now, the pronunciation, enlarged another point that was not granted by the Sharola Verma, that was the general damages. My lord, general damages on 3 heads, my lord, the Pranay Shetty, my lord, the constitution decided. My lord, loss of estate, that was my lord 15,000 should be given according to schedule section 160.
That is multiplier theory, multiplier.
No,
No,
general,
schedule. That schedule.
my lord, what schedules, my lord, loss of estate granted only 2,500. But in Pranay Shetty's case, it was decided it should be 15,000. My lord, and loss of funeral expenses, my lord, the schedule says 2,000, but my lord, the Pranay Shetty case is 15,000. Now, my lord, loss of consultaria in case of a death of a husband, loss of consultaria. My lord, where 5,000 was granted in the schedule, but in the Pranay Shetty's case, my lord, I am facing Pranay Shetty টা নিয়ে এসেছিস তো? In case of Pranay Shetty, it should be my lord 30,000, 40,000. So my lord, 40,000, 15,000, 15,000, totaling 17,000. And in Pranay Shetty, which was decided on July 2017, my lord, Pranay Shetty also says if every 3 years 10% should be increase of the general damages. If the accident took place, my lord, in the year 2020, so it should be, my lord, instead of 70,000, it should be 77,000, 10%. If it is 23rd, well, if it is, my lord, the accident took place 2023, my lord, it would be 84,000. Now, my lord, our case is decided in the year 2025. So I pay, my lord, 84,000. That was the grounds I have taken in my cross agreement. And my lord, the Pranay Shetty, Sharala Verma also granted, my lord, also considered the future prospect to be government employee. My lord, where the limitation
No, this is government employee.
is a government employee. My lord, in case of government employee, my lord, the Sharala Verma, my lord, restricted up to the age of 50 years. There should be, my lord, the future prospect. But above 50, my lord, there is no future prospect. But the Pranay Shetty's case, my lord, says no, 50, above 50 to 60, my lord, in case of government employee, the future prospect would be 15%, and in case of self-employed or fixed wages person, the, my lord, the future prospect would be 10%. That was, my lord, decided the constitutional base. Not Sharala Verma, my lord, modified. What my lord, Sharala Verma says up to 50, there is no, my lord, future prospect. But in Sharala Verma, the up to 60 years, the person who died or who got injured, my lord, are entitled to get, my lord, the future prospect up to 60 years. Here, the police constables, my lord, from the documents, from the materials on record, at the time of accident, he was aged about 51 years. So, my lord, my clients are entitled to get 15% of the actual income for the tribunal assets. My lord, supposing, my lord, 1 lakh. So 15,000, my lord, 50% is 15,000 should be added. 1 lakh plus 15,000. That is income per annum, my lord. But here the income has been, my lord, be produced. Where the provisional tax, my lord, says 1,150. That has not been deducted. That ground was taken by Rane Field. That I consider that the Rane Tribunal judge committed error not deducting the provisional tax. Income tax is zero. Now, my
Income tax was deducted, but not professional tax.
on the basis of the, my lord, the December accident took place January, December salary slip. Even if, my lord, the employer's, my lord, evidence is there, here is, my lord, the three oral, my lord, witnesses. One is claimant PW1, Niyoti Kumar. PW2 is the SI of police station who brought the matter, the salary register.
An eyewitness, any?
Eyewitness is PW3. Is page matter 28 to 30 of my paper. Everything, matter there is no. Matter the grounds taken, matter by the insurance company that there is a violation of route permits. Now, Malar, if your lordship go through the written statement of the Malar Reliance General Insurance Company, there is no Malar the point taken regarding route permit. Even if no evidence were produced from the Malar side of the
What is your
Reliance
problem?
General Insurance Company. So this point, Malar, is the first time appellate court, Malar, it cannot be sustainable. My submission is regarding the immediate charge sheet. Malar, my client filed FIR, my client files Malar my client files the Malar the charge sheet. While it does not appear that there is a Malar the violation invalid route permit. Even if Malar the regarding route permit, Malar my landed trade says insurance company desire to pay the entire compensation but recovery right. Malar recovery right is Malar is not always Malar considered.
The question is that is between the insurance company and the vehicle owner. Claimant is not prejudiced by that.
Claimant is not.
Why are you
But
submitting?
Malar, I would submit Malar as a officer of the court. Malar in the Malar the guidelines of the Honorable Appellate Court and also our High Court's Malar many judges decided. But the insurance company did not produce any evidence.
Anyway, that's a different issue.
Divine issue.
Whether there is a findings or not.
Only
How
point.
are you
only-
prejudiced? No,
Only
দেবো
point
কেন?
matter I have considered that the landed tribunal committed error, Malar, in not deducting the professional tax. Because Indira Srivastava's Malar, I have got the decision of the Malar Supreme Court, where the income Malar, how income has been deducted. Income is the gross salary less Malar the permissible statutory Malar the deduction.
That is GPF is there.
GPF is entitled. Only is professional tax or income tax. Here from the page.
No, there is some statutory deduction of the GPF also.
GPF not. GPF is not permissible for deduction. GPF is also after retirement or after premature death. Malar their legal heirs are entitled. Only professional tax or income tax would be considered by the tribunal. That should be to the the room of the government. That should be given by way of tax to the government. Now, Malar, here the tribunal, Malar, the awarded 29 lakhs.
Without deducting that professional tax.
Professional tax that counts. But regarding the valid permit, I would submit that since Malar in the written statement, if your lordship go through the written statement of the Reliance General Insurance Company, Malar, there is no iota of Malar or averments made in the written statement that there is a
Paragraph number 30 of the written statement. Kindly go through, my lord.
Yes, page.
Page 13. Without reading, don't submit.
whatever Malar.
Yes, paragraph number.
Paragraph number কত?
Paragraph number 30.
Driving license.
Who said?
And
Read
route
it.
permit.
And route permit. Read it kindly, my learned friend.
Paragraph 30.
Yes.
The driver of the above noted vehicle has no valid and effective driving license route permit. Driver Malar did not have route permit.
Means
What is the meaning, Malar?
driver
No.
and route permit. Please read the word.
Oh, driving license was seized.
My lord, driving license was seized and route permit was not
Okay,
seized.
okay. So
My
route
lord,
permit was
he-
not
he
seized.
thinks that a driver also wants to have a route permit. What? You understand, please. The
Route
paragraph
permit of
number-
the vehicle, not the driver or of the vehicle.
That manner, 1 watt or 2 watts manner, that means manner many things, manner. I leave it to your lordship. Whether driving license or route permit, manner. Even if, manner, in the written statement, even if they have taken the point, but they cannot brought any, manner, the
My lord, how is my learned friend prejudiced with this my right to pay and recover? I don't understand, because I have already deposited the entire awarded amount along with interest, my lord. Let him.
Anyway, you see, the matter, you see, the court has to be satisfied as to whether there was the driving license and this route permit was there or not. If the court is satisfied that yes, it was there, or the insurance company did not take any steps to adduce evidence, whatever it is, then no question. Suppose the court comes to a finding that yes, it was not there, so court will direct pay and recover. So in this case, in this situation, claimant has nothing to suffer.
I leave it to your lordship. I am not manner against the manner, the appellants. Manner,
তাই বলছিলেন
Anyway, now you come.
নিজেরটা করো না
আচ্ছা সাইড টকটা বন্ধ করো না, আমাকে মামলা করতে
একটু বেশি বলতে
manner, here is the manner, the apportionment under the 40 and 60. 40% manner has gone to the manner, the Royal Sundaram. That portion has been manner satisfied. And there is no appeal by the cross appeal by the Royal Sundaram.
Okay, where is that order? Let me see.
Yes, your lordship kindly turn to order page 31, it starts.
No, paper book. Which paper book?
Paper book, page 31.
Page 31. Yes.
Now, my lord, your lordship kindly turn to issues. My lord, page 33. What are the issues, my lord, decided by the tribunal? Is the case maintainable in the present form and content? Do the claimants have a cause of action to file the claim case? Did Adit Kumar Sharma, the deceased son of the Chibosa, died at the fatal of road traffic accident involving Atu? Whether the said vehicles are insured on the date and time of the accident? Whether the drivers of the aforesaid vehicles have valid driving license for driving the vehicles or not? Are the claimants entitled to get any relief as paid for? To what other relief, if any, the claimants are entitled? My lord, there is no minor issue regarding the the permit.
So-
Now, my lord, your lordship kindly turn to the calculation portion. Everything, my lord, the tribunal come PW1, PW2, PW3.
Yes.
And my lord, your lordship kindly turn to page 39. Page 39, my lord, at
Yes.
the first paragraph, may I permit it to read?
Yes.
Therefore, both the owners and insurers of both the vehicles are liable to compensate the petitioner jointly severely for the death of a road traffic accident reported in this case. This was the constable of police by profession and he used to get monthly salary from the police department of Government of Uttar. Said fact is not disputed in this case. In this connection, PW2 Sanjay Chatterjee, one of the officer of the Indapur police line, produced service book and salary statement of the business from the office of the Indapur. PW2 duty authorized by SP Indapur, the original service book and salary statement of the business issued by the SP Indapur, original service book proof and marked as Exhibit 11. Therefore, the same was written after giving the substitute photocopy of salary certificate has been marked as exhibit. These are the all documents coming from the government, and as such there is hardly any scope of disbelief. Accordingly, I have no indication to hold that the business is to receive rupees 30,691 per month as gross salary. After statutory deduction, he used to take net salary 29,533. In a motor accident claim case, gross salary of the business is considered as his income accordingly yearly income of the business is taking. Under the learned tribunal taking gross 30,691 per month is the into 12, that comes 3,68,292. Now on the next page, page 40. 1/3, but there are three payments. 1/3 annual income must be deducted as its personal expenses, having been aligned after deduction of 1/3 annual income, a sum of rupees 3,68,292 minus 1,22,000.
That is dependency.
That is 1/3, Malad. That
Dependency.
is
No, that is personal, his personal expenses.
deduction. If he had been alive, Malad, he Malad for his survival.
So after deducting this 1/3, that is 1/3 is for the personal expenses.
Is personal.
So this is the loss of dependency.
Loss of dependency.
So this is that is 2,45,520.
520 is available for calculation of compensation in this case.
That is loss of dependency. That is the
2,45,520. This is died at the age of 50 years, as it appears from the exhibit 11, copy of service book. As per service book, the date of the birth, date it should be fixed. Date of birth
2,45,528.
18,000 died on accident took place 12/1/2000. So on the date of death, it was 50 years, 2 months, 15 days. On the date of accident, it was 15 years, 2 months, 9 days. So, Malad, as per the Sharala Bharma, Malad, the future costed to be 50 to 60. That was reflected in the pronunciation. Malad, that was not considered by the tribunal.
The question is, you see, decision of the is Sharola Verma's case.
No.
Pronasheti was argued before the bench, before the court.
No.
Where I don't find in the judgment.
The case was decided, your lordship kindly say, the case was decided, Malad, in 2017.
Sharola Verma's case, a multiplier of 11 is applicable.
Yes.
So,
Malad, the case was decided after pronouncement of
so
pronunciation.
27 lakh is the pecuniary, so and so is the pecuniary loss. So apart from pecuniary loss, non-pecuniary loss of constituents, so and so.
Malad,
So
I am reading Malad page 40.
Yeah, 40, yes, 40.
After an application of 11 multiplier is rightly applied. 11 multiplier amount of compensation 2,45,000 into 11, that is 27,808. This amount is pecuniary loss. Apart from the above pecuniary loss, the petitioner are entitled to non-pecuniary damages like loss of consortium, because petitioner number 1 is the spouse of the deceased, loss of estate and funeral estate. There is no yardstick of declaring of non-pecuniary damages. Generally, the lump sum is allowed on the basis of hypothesis. Petitioner number 1, the wife of the deceased, is entitled to a sum of rupees 1 lakh as loss of consortium. My lord, I stop here, my lord. My lord, I consider that point because the loss of estate as per the pronunciation was granted by the 40,000. But here the learned tribunals, my lord, granted by the 1 lakh. It should be. It
No.
should be, my lord.
1 lakh is the, no, as
Consortium.
consortium is 1 lakh.
1 lakh.
Okay.
It should be, my lord, it should be 48,000.
And regarding loss of estate?
Loss of estate also, my lord, giving, my lord, the loss of, and because nowadays the honorable.
Next page.
I shall argue, my lord, next page, that the after pronunciation, there is at least, my lord, 15 judgment, the honorable appeals court consider pronunciation, that loss of consortium 40,000, loss of estate 50,000, or funeral expenses 50,000. My lord, the increase. My lord, why the loss of parental affection, consortium,
No, the
40,000
case was instituted prior to Pranay Shetty's judgment.
No, case was
Yes.
decided after,
No, no, instituted when?
instituted before. This is 2010 accident. The case was decided after delivery of the Panar Pranay Shetty. Pranay Shetty decided my lord July or October 2017, and this case was decided in November 2017. Now, my lord, page 41, your lordship kindly come. A sum of rupees 75,000 is just and proper loss of. This is also by the, my lord, this is also the this amount. It should be, my lord, it should be 15,000 plus, my lord. That is
No, according, so you are admitting that instead of rupees 1 lakh, okay,
1 lakh
it should be rupees 48,000
48,000.
or 50,000 at best.
No, it is 84.
নো কেন জজ সাহেবের উপর বলছে নো
My lord, according to Pranay Shetty,
জজ সাহেব আমার সঙ্গে কথা বলছে তোমার সঙ্গে
Anyway, 48,000, you see, after all, the tribunal has to,
48,000
you see, whether it
what
is,
I am submitting.
yes,
Your lordship.
because you see, it's not a mere calculation. Court has to decide what is just and reasonable.
Just reasonable.
That is the thing.
my
My
lord,
lord.
my lord, my lord,
My lord,
according to Pranay Shetty, it is 70,000 and all our the judgments are accordingly given.
Okay, so
70,000 total.
48,000 is what according to you?
48,000 is, my lord, is
কি উল্টোপাল্টা বোঝাচ্ছে
40,000.
বলুন।
That 10%, 10% in
পাচ্ছে যা
every year.
পাচ্ছে বলে
That is
যাচ্ছে।
2017 up to 2020 and 2020
আরো 10 লাখ টাকা নিয়ে।
2023, it should be, my lord, the 20%. So 10% of 40,000, it should be, my lord, 48,000. Now, your lordship,
Yes, and the next is 75,000. Yes, 75,000.
75,000 just a loss of it. It should be 18,000. Because 15,000 into 15,000 of 20%, that comes minus 18,000. So 48,000, 18,000, and minus 25,000. It's also minus 18,000.
No, regarding 25,000 is the funeral expense.
Funeral expenses. That was also minus the amount, but I shall minus argue by the Calcutta, not in this case, that the Honorable Apex Court, minus release of decision, at least minus 15 cases. Our High Court also granted the Hilarian consideration. Hilarian consideration is loss of affection, minus of son or must be parent towards the son or towards the parent.
So it's instead of 1 lakh, it is coming to some 91,000 something.
84,000.
No, 48, yes.
8,000, 18,000, 18,000. It comes 84,000.
84,000 instead of 1 lakh.
1 lakh, no,
But-
my lord, 2 lakhs total, page 41, my lord.
That
Therefore, total rupees 27 lakh plus,
Page 41, my lord.
oh, plus 2 lakh.
Yes,
2 lakh.
2
2
lakh.
lakh would be, my lord, 84,000.
Yes.
চিতো আবার বলছি বলে।
কোথায় বলছো? কোথায়
Therefore,
বলছো?
total amount of compensation is rupees 27 lakh plus 2,029 lakh. Now, question.
That is 27 lakh, that is the compensation, loss of dependency, plus this loss of consortium, loss of estate and the funeral expense, total compensation.
Total compensation.
That is loss of dependency is 27 lakh something.
Yes.
This is 2 lakh is consortium, estate and this funeral expenses. So instead of 2 lakh, what should be?
84,000.
84,000 instead of 2 lakh.
একসঙ্গে
Sir, I am giving the calculation chart.
Okay, instead of, you see, if you, instead of following Pranay Shetty, if you follow Sarola Bharma, what will be? This instead of,
General damage has not considered.
no, this, no, loss of consortium and loss of estate.
বললাম না ওটা
Not
হবে না।
considered. The Pranay Shetty
বলবো
considered.
কিন্তু জজ সাহেব, ওটা হবে না।
You know, your lordship,
Calculation
because
sheet
before
দেখাবো।
writing down, your lordship will kindly hear me, because this entire writing would be of no use.
No, let us, I'm just clarifying the factual aspect only.
সুযোগ পাবি তো
জমা দিচ্ছি কত 60%, 40% এসব তোরা
my calculation would be my lord.
Okay, so this point you are submitting that it should be, if we follow Pronoy Shetty, then 84,000. So there is no observation of this learned judge that Thorola Verma is followed or Pronoy Shetty is followed. Anyway, let me see that.
My lord, this
না
is
বুঝে
the
বাবার মতো ঝগড়া করতে
chart I have.
ওই করবি তাহলে সারা
My lord, before that, your lordship kindly, my lord, I give it, my lord, the page 80, page 82 of my paper, page 82 of my paper. And page 81. First, your lordship kindly see page
Yes, page 81.
This is a salary statement of the month of December. My lord, the accident took place January. Just, my lord, before month, my lord, the salary statement. While it appears, my lord, the total income was, my lord,
30,691.
1,699, right hand side.
Then GPF 1,000.
GPF not permissible. Only, my lord, your lordship kindly see the column number 1, 2,
Okay,
3.
professional tax is,
150 should be deducted.
so that it comes to 29,533.
Yes. Number no, 30,691 minus 150.
That is 30,000.
30,691 minus that. Your lordship kindly see the calculation chart.
30,691, 150 deduct means 30,541.
541.
But 41 into 12, yes.
To 12. That comes 3,66,492.
So according to you, future prospect is,
15%.
that is 54,000.
That is 54,000. Now total is 4,21,461. 466. Now 1/3 deduction. That is 4,21,468 minus 1,40,000.
So according to you, this future prospect is not taken into consideration. That is 54,974 by the learned judge.
Yes, but in my cross appeal. And also I have taken.
So according to you, have you taken this point of Shorola, this Pronoy Shetty?
Yes, yes.
The judgment was delivered after Pronoy Shetty.
Yes, I have taken. Your lordship kindly see my cross appeal. Page,
They did not cite this Pronoy Shetty in the tribunal, my lord.
page 41, your lordship kindly see of my cross appeal.
What was the rank of this person when he was in service? This person died, traffic constable.
He's a constable.
Shorola Verma has taken
Only to the government.
this person is also government.
Employee.
So as far if Shorola Verma
restricted up to 50 years. Here the disease constable is above 50 years. But the Pronoy Shetty say from 50 years to 60.
Now the question comes for consideration is how much will be the difference if future prospect is not taken into consideration. How much additional compensation will get? 15% of the
Pronoy Shetty.
15% of the total income.
Total income. That minor charge minor I have taken. And multiplied since he was 51 years, as per the Shorola Verma Pronoy Shetty, the multiplier will be 11. Mane, your lordship kindly see my calculation chart. 51 years, that is 28978.
Your lordship, can I come to you 1 second? Why did this call in the back? Not, I'll come and address your lordship.
So, my lord, it comes, my lord, 30,000, 30 lakh, 90,000, 758.
So you would have been entitled to damages of 31,74,458, according to you.
Yes,
And how much you are awarded? 29 lakh.
29 lakh.
29 lakh, how much?
29 lakh 808. That was Manad, your lordship kindly see.
Not much difference.
Manad, your lordship kindly see page 44 of my paper book, the judgment portion. Page 44.
Yes.
OP number 4, Royal Shutdown is directed to pay 11,62,000 out of 29,808 to the petitioner together with interest 6% per annum. Royal Shutdown has complied. That amount, Manad, has been paid. Now, Manad, account pay change and so on, so on, so it default the petitioner.
So both the vehicles are involved, according.
Both the vehicles and both the vehicles are insured. One is Reliance General Insurance, Reliance Insurance Company says.
Anyway, this is complied. 11 lakh. That is paid.
But Reliance has not complied. Reliance has come, Manad, challenging the award in this appeal. The grounds taken, the two grounds. One is, Manad, the lack of valid permit, and Manad, second is professional.
Now you see, you have already accepted. So far the one portion is concerned, you have accepted this compensation.
Yes. And also, Manad,
So part you see, you are challenging the award, but part of the award you have accepted.
Manad, when your lordship is delivering the judgment after considering my cross appeal, it should be, Manad, increased, Manad, from 29 lakhs to 31 lakhs.
No, but you have already accepted this. Part of this awarded sum you have already accepted.
Yes, Manad, I filed the cross appeal and delay in filing cross appeal has been condoned by the earlier court. That court should be, Manad, taken into consideration.
No, question is, you see, I think prior to the filing of the appeal, you have accepted this sum. This 11 lakh.
Accepted, Manad, they have deposited. My clients have withdrawn.
You have they have deposited, your clients have withdrawn.
Withdrawn. And that is the Manad Tiki amount, 11 lakh. And if your lordship calculating, my lord, the interest, my lord, it should be, my lord, more than, my lord, 38 lakh. কত রে আরো বাড়বে?
2 লাখ টাকা বাড়বে। 2,74,000 বাড়বে। না 29 লাখ টাকা অ্যাওয়ার্ড করেছিল, 31 লাখ টাকা।
So 31,74,458. It is the principal amount.
Yes.
Principal amount. And Malad, your lordship kindly see the next column, Malad, in calculation, Royal Super Malad will be paid 31,74,000 into 40%, minus 11 lakh they are paid. 11,60,000 so Malad, it comes, Malad, 12,69,000.
minus
11 lakh they are paid, 11,60,323.20. That comes to 1,09,468 with 6% interest from the date of filing of the claim application. That is 24/11/2010. While from, my lord, I am filing the date of filing, your lordship kindly.
No, that is there. That is a matter of record. From the date
your
of.
lordship kindly see in the paper book, my lord, page 1. Date of filing is.
Yes.
That is 24 November 2010.
Stamp.
It is a, my lord, the court's official seal and endorsement.
Yes.
That date of filing. From that, my lord, the section 171 of the Motor Vehicle Act says, whenever, my lord, the tribunal passes any award, that should carry interest. That may carry interest. And, my lord, he says the Honorable Appeal Court and our High Court says he shall be treated as a shall. Whenever the award pass, it should be, my lord, granted interest. Because they are enjoying the money in their pocket, not paying to the claimant.
No, interest, you see, that is interest
We have
is the,
deposited the entire awarded amount along with interest at the time of obtaining stay on 28/6/2018, my lord, and he is saying
interest is from the date of
we are
filing,
enjoying the money.
realization, or from the date of the award,
No, date of filing of the claim application.
till realization.
Yes, we have deposited the entire awarded amount along with interest.
Another limit note. It is a case.
Anyway, so far part of the awarded amount, part of the awarded sum has been satisfied by one insurance company.
বাকি তারা দেবে।
Only my lord says that the differential amount from the date of date of filing of the claim application till its realization, that I'm claiming in my chart.
So what is there?
Yes, my
এই
lord,
অ্যামাউন্টটা বলো।
your lordship, the first part with 6% interest, that is 1,09,460.
Okay, let us consider the judgment of the Honorable Apex Court and the MSCC Act also regarding interest.
Interest, yes.
Yes, yes.
Motor vehicle act there.
ওইটা নেই।
That is there. That is may is there. But what is that order regarding that shall?
Motor vehicle act আছে দাও তো একটা। আরে তুই তো বই নিয়ে আসিস না কেন? এটা মামলা রায় সিং এর বইটা নেই। মানে section 171 is clear, but you lost
No, you are relying upon that authority also.
authority.
That
yes,
may
yes.
has to be treated as shall.
Well, it is everybody knows that.
Yes, yes. I also want to know. I also want to be everybody. Let me know it. No, I have actually dealt with these cases while I was in the district court, many claim cases. So interest is there, nothing unusual. Interest is there. So now you are claiming this amount. So let me see that decision also. So earlier Sharola Verma was applicable. Now this Pranay Shetty has come.
My lord, I'm placing my lord the judgment of National Insurance Company versus Indira Srivastava, which was decided in 12 December 2007. What amount should be deducted when the tribunal is making calculation?
So this is also prior to this Pranay Shetty. Sharola Verma was there.
It's only confined to deduction of professional tax.
Okay, so which paragraph?
Paragraph says, my lord, your lordship kindly see, my lord, page 5.
Yes, para 15.
Paragraph 15. We may, however, notice that the determinant of this code is Asha and other persons company. Upon events have been paid by Mr. So, yeah, for continuing case while life is taken one, several parks were invented in Sydney. We may reproduce the several certificate herein now. Now, uneasy basic pay to unpaid. They shall pay FDA, EBA, CTA. Now, our net payable 6,000.
You see, this is another observation also. You see, what would be just compensation must be determined having regard to the facts and circumstances of each case.
Yes, but your lordship kindly see, this code in Asha did not address itself the question raised before us. It does not appear that any precedent was noticed nor then just compensation was considered in the light of the changing social condition and also parts which are paid to the employee, which may or may not attract income tax, your lordship kindly, income tax or any other tax. What
Yes, which paragraph? Yes.
paragraph page 6.
Yes, page 6.
Paragraph 15.
Yes.
And the basis for considering the entire pay parts, what dependents have lost due to the nature of the compensation for future loss towards the family. The Rati Menon versus Union of India, this code after considering so Now, my lord, your lordship kindly come to the paragraph 18, paragraph 19. If the defining of the word income is taken, logical calculation, either in terms of money or otherwise, consideration of the purpose of payment of income tax or provisional tax. Although some elements thereof may not be taxable or will have been otherwise taxable, but for the exemption conferred thereafter. That is also paragraph 22. Second of the now paragraph 8 page paragraph 20 that not to be can be Onanja, it cannot be Onanja or is with of nothing but confident or that all facts and answers. We have to allow the reduction of income department and tax benefit. Only that we have to that is constitute, but we decline to possibly the accident are very possible. This is the model manner, the decision of Indira Srivastava. Thereafter, many cases manner, the Supreme Court said only deduction manner, the amount part is the deduction of manner, the professional tax.
So if this is followed, for example, Justice Sinha's judgment is followed.
Yes, I am grateful to you, Lord.
Suppose
Yes,
the
yes.
court follows this, then what will we get? Then only that is
Only 150
no, that is the income tax.
income, no, only
Not-
professional tax.
No, actually, you see, income tax is usually deducted from the salary of
That
the.
is, Mala, that is the because I government's duty.
That is not reflected. Tax deducted at
No,
source.
no, that was while a pay slip does not reflect.
Tax deducted at source.
Deducted at source.
So, as per no, what is this? Para 24.
Para 24 of
Para 24 of this judgment.
Srivastava.
Yes. Deduction of medical reimbursement.
Medical reimbursement. And that was also, Mala, the overruled by medical reimbursements, also, Mala, entitled. Even if, Mala, the government, ESI, or Mala, some Mala, governments, Mala, the park, give some money, Mala, to the government, Mala, the employee who faced the motor accident in the hospital. That should have no correlation with the Mala, the payment of compensation as decided in the motor claim case. That was overruled, Mala. But Indira Srivastava is a model where the professional tax, income tax, or the taxable amount be deductible. Others, that is take home package. All others, the even if provident fund, the medical allowances, and the other allowances, all are allowed.
So here you see,
Your
honorable court did not agree with regard to deduction of medical reimbursement and tax element.
Here also, the in our
Issue is
case,
not there.
in this case, medical
Reimbursement or
my client although play but did not consider. I have not taken in my cross appeal. That accident took place on 10th 1/2010, and he died after long treatments on 18th. So there is some medical the expenses that I have not claimed. In the claim application I claim, but it was not considered. Though I have not taken in my cross appeal, but I only confine that professional tax should be deducted. And the future prospect, which was not considered by the tribunal, that should be given 15%. and interest is 6% from the date of filing of the claim application.
So, as per the tribunal, the learned court's order, the interest is awarded in both the insurance company, that is from the date of the award.
Date of the filing of the claim application.
No, what is the award? What does the award say?
Award says
Yes.
from the date of filing.
No, if it is there, it is there.
No. No, but the tribunal has not mentioned.
Just simplicity and interest.
Exactly.
My lord, from date of application till date of realization in ordering portion, it has been clearly mentioned.
Where?
What is my learned friend reading?
No,
like?
which?
তুমি তো পড়ে এসে এত কিছু বললে।
কোথায় পড়েছে?
Yes, the petitioner to get a compensation.
Yes, the petitioner to get operate.
Filing of the application till the date of realization.
Fine.
So that is there.
Yes.
Yes.
বলবে রিলায়েন্স
Reliance has how much amount has been deposited, I don't know. But if you lordship allow my the cross appeal, because cross appeal involves the main points, the future prospects, a government employee should be considered as.
See, this Justice Sinha's judgment, it is stated that although this medical reimbursement, no, here you see, here the challenge was that the High Court has deducted the medical reimbursement.
Medically, reimbursements, that was not reflected in the pay.
His rise of income was not taken into consideration by the learned courts. Anyway, whatever is just and reasonable, that should be awarded.
I'm confining, I am giving, consider the 2 points that professional tax should be deducted. Second point is that the general damages, which the tribunal granted 2 lakh, it should be 84,000.
So one of the insurance company who have complied, they have not come with this appeal.
Yes. So they have not say nothing.
But they are a party, just a party.
Just a party.
Because the insurance company who is to comply
is the Reliance and insurance company.
No, my lord, it will be if the total principal amount is enhanced, then it will be again 60-40%, which the tribunal has awarded.
The petitioner claimant, the appellant claimant.
No,
has
I
already,
am the appellant.
No, you are the appellant insurance company,
Yes,
and you are Mr.
they are the respondent, and we have preferred this appeal in the year 2018, and now he has come in 2024, my lord, to file the court.
Oh, 24.
Yes.
And
And my lord can see how my learned friend acts, and he has condoned the delay, so much delay.
Condone?
I mean, you have obtained the order of condonation.
Condonation petition
আমি
is allowed.
কি বলছি সেটা বোঝো, শোনো, তারপরে বলো।
কি বলছো তুমি?
বললাম যে তুমি কন্ডোনেশনটা নিয়ে নিয়েছো, অর্ডারটা, যেটা নেওয়ার ইয়ে ছিল না।
That was allowed by Her Lordship the Honorable Justice Honorable Bandyopadhyay.
It is an afterthought, my lord, after so many days.
Yes, now what do you say? You
My lord,
reply and
yes, I will.
some relevant decisions you cite.
11 decision by the Lordship Ballard, Pranay Shetty.
Have you filed those copies? Pranay Shetty and Sarola Verma. I'll just keep it tomorrow for further.
But in course of this ballot, I will place the ballot.
In course of the day, you will file it. Yes. You are just a party in this matter. You have not come up in the appeal, but you are one of the opposite party.
My lord, I would be the sufferer as well. If your lordship, my lord, decides, my lord, against the insurance company.
Enhancement, regarding enhancement.
I shall be a sufferer.
Yes, so far this the cross court is concerned,
I'm grateful to your
you
lordship.
will be affected.
I'm extremely grateful to your lordship. My lord, a lot of submission has been made, my lord, a lot of those who are misleading as well. May I just indicate?
Always, my lord, in every court, in every judge, my lord, he says, and I am always misleading.
You are misleading. You are misleading.
My lord, your lordship understand later. Who is misleading?
Anyway, records will speak for itself.
Yes, yes.
Yes.
Babu, একটু বলতে দে, please.
তুই মিসলিডিং কথাটা বলিস কেন?
ও মিসলিড করেছে না তুমি করেছো এটা বলেছি?
ও করেছে
আমি কি বলেছি? আমি কলা খাইনি আগে লাফিয়ে লাফিয়ে? Milord, accident of 2010. My vehicle was stationary. I'm for the Royal Sundaram, Milord. The police constable, Milord, was on the road. One truck hit the police constable and my stationary vehicle as well. Learned Tribunal, Milord, said that your vehicle was stationary, nothing doing. I'm assessing approximately 29 lakhs in the compensation amount.
No, actually,
Lordship.
the vehicle which hit the stationary vehicle
Lordship.
also hit the constable, both.
Yes.
Simultaneously.
Yes. Yes.
The stationary vehicle hit the constable.
Yes.
And the vehicle
How
which
can a
was
stationary vehicle hit? Milord,
ওটা গড়িয়ে গেছে দাদা।
Milord, one vehicle was stationary. Constable was next to the vehicle. One truck came. It hit. Constable was
From the
hit.
backside.
From
Not
the backside.
from
Yes,
the backside.
From the backside. Constable was hit. Stationary vehicle was hit. Whichever way, Milord, vehicle was stationary. One vehicle came running. Constable was on the road. Constable died. This is the exact scenario.
No, it was not that. It was the vehicle which was standing in the middle of the road. In front of that constable was standing and a
বলে নিয়েছো ছাড়ো না এবার
হ্যাঁ তো ওই ভেহিকলটা এসে পেছনে মারলো তোমার স্টেশনারি ভেহিকলটা গিয়ে ওটাকে মারলো তাই রয়েছে দাদা দেখো ভালো করে
Anyway, the findings is there. Okay.
হ্যাঁ
Anyway,
Milord, Learned Tribunal said the stationary vehicle would pay 40% of the total assessed amount, and the vehicle, Milord, which came and hit these, Milord, it would pay 60%. Milord, this 40% I am responsible, Royal Sundaram. Milord, I have paid, satisfied my share of award. For the 60%, Milord, Reliance, the truck. My learned Milord friend was there. She has preferred this appeal. She is disputing her liability, Milord, on the ground, and that the vehicle was not having route permit. And she was praying for a liberty to recover the amount from the owner of the vehicle, provided my lord is satisfied on that issue. This is clear. My learned friend here, Milord, he has come up for enhancement, Milord, mainly on two grounds. Milord, he says that future prospect 15%, 1.5, which his client was entitled to in view of plan SAT, he did not get. And Milord, he also says, Milord, this Milord, general damages was already given in excess 2 lakhs. Milord, in his fairness, he concedes that it should be brought down to the ratio as decided by plan SAT. This is the main ground, Milord, of his enhancement. Mainly is on future prospect, Milord. Milord, I join issues on the point of quantum. I have satisfied my share of award. As far as my learned friends, Milord, right to
now
recover.
suppose that quantum is reduced on the basis of your learned friend's submission. That means you are, see, he has conceded that so much tax ought to have been deducted, and so far the loss of consortium, all these things.
Yes.
So if it is reduced
Lordship.
on his submission,
Lordship.
then you can get something back probably.
Milord, it would not be reduced. I'll tell you, Lordship, 5 minutes. Because 15% future prospect in any event has to be granted. 1.5. So 15% of this, Milord, 29 lakhs odd, Milord, is a substantial sum. So even if what he concedes and what subject to what my submission is, Milord, amount is reduced, still, Milord, it would be balancing that 15%. He would not have to pay anything back to the insurance company. And Milord, in any event, Milord, since this particular appeal has not been preferred by me, Milord, so I would not be asking for any money back from him. But I would try to see to it that no enhancement is made. As far as my learned friend's contention is concerned, Milord, I am not getting into that. Your Lordship will decide the right to recovery. Now, Milord, Sarla Verma, Pranay City, Milord, a lot of water has been flown down the Ganges since then. Sarla Verma is a judgment of 2009, a division bench judgment. Milord, prior to Sarla Verma, Milord, there was a lot of confusion with regard to the assessment of income. Milord, what is this motor vehicle act, Milord? What is it all about? This is quantifying the value of an individual's life. Today I die. What is the value of my life? Anybody in this court or in this world, if he dies, this Motor Vehicle Act decides that you, an individual, what is the value of your life in money terms, Indian rupee terms. This is what, the Motor Vehicle Act today, as it stands, is deciding. For all individuals, it is. There are different parameters to decide this quantum of compensation for all individuals. What is your income? What is your age? How many dependents you have? But these are the different parameters. If you do not have any income at all, then what should be considered as your notional income? There were different judgments throughout the times. Original Act of 1938, Motor Vehicles Act, my lord is aware of. Then the major amendment was made in 1984. And then 1994. These all, most of these cases, what my lord would be taking up now, would be of 1988 Act. Because the last major amendment was of 2022. 2022 amendment, after that, the claim cases have been filed in tribunal. In 99% of those cases, awards have not been passed. So they have not ripened up to come up before your lordship, after 2022 amendment. So your lordship is mainly concerned about 1988 Act. In 1988 Act, as I was submitting before your lordship, there was a lot of confusion with regard to the assessment of income. One individual judge, for example, hypothetically, used to say that I'll grant 40% future prospect. Another would say, no, why future prospect? At the time of his death, he was getting whatever amount he was getting, he will get only that. Monthly income, if there was no income, the schedule your lordship is aware of, 1994 Act subsequent amendment.
Yes.
Schedule in under section 163 capital A, there was a chart as per the schedule, that person having no income would be treated as a person having notional income of 15,000 rupees per annum. That is 1,250 rupees per month. Right. This is what the chart, Motor Vehicle Act itself, the statute said. Some of the honorable judges or learned tribunal judges, or High Court said that, no, why 1,250? We will consider 3,000 rupees. Somebody said, no, we will consider 2,000 rupees. Somebody said, we will consider 5,000 rupees. On every aspect, there was a lot of confusion. Sarla Verma in 2009, for the first time, Honorable Division Bench, Supreme Court, used the term, the rule of thumb. It said, by a rule of thumb, we say and we quantify that this should be the methodology which should be universally followed. What should be the multiplier system? There was a lot of confusion with regard to the multiplier system as well. I am 41-year-old. I would retire at 62. So my 22 years, my service is left over. So whether the multiplier of 22 should be used, or 10 or 5. These were the confusions.
Ultimately, the general concept is what is just and reasonable.
What is just and reasonable?
Ultimately, the court has to come to the conclusion.
Extremely grateful, my lord. But what is just and reasonable, my lord? Just and reasonable differed in the eyes of each individual judge. For my lord, the just would be 1 crore for my death.
That the tribunal is empowered to pass what the court thinks. Just and reasonable.
Lordship, my lord, because of this confusion, my lord is considering my life worthy of 1 crore by way of my lord's calculation. Another honorable judge says that no, he is only worth 40 lakhs. Another honorable judge, by way of his own just assessment, would say no, he was 5 crores. So, my lord, in order to avoid these confusions, Sarla Verma said, no, rule of thumb, we say this should be the methodology. This should be the multiplier. This should be the future prospect. This should be this, that. For around 7-8 years, it continued. There were, 1 or 2 dissent voices of Supreme Court. That would always be. There was another confusion with regard to this consortium. In case of death, consortium, what should be given? General damage. The collective head of general damages, has funeral expenses, loss of estate, and consortium. Every individual judge, he was thinking differently. Sarla Verma said, in totality, all these three heads combined together under the head of general damages should not exceed 20,000, 20. These three heads combined together. Somebody said, no, why 20,000? Consortium, we will give 1 lakh. Somebody said funeral expenses is now 50,000. Dissenting voices were there. Pranay Sethi in 2017 sat together with all these. He said, no, again, there is so many confusion. 5 judges, Miller, of Honorable Supreme Court sat together. And then they, Miller, taking the principle from Sarla Verma and taking most of the calculation part from Sarla Verma, tweaked it here and there and fixed one specific methodology. I'll just show it to your lordship. Beta Joshua ke din thek. Milord, the top is Sarla Verma, the parent judge bench.
Yes.
And then, Milord, thereafter, Pranay Sethi, the 5 judges bench. Milord, now this Pranay Sethi is the law of the land as far as the Motor Vehicle Act is concerned with regard to assessment. Since it is 5 judges bench, every single dissenting voice, if there be any, if there be more than one, if even there be 100, I take that way, Milord, is bound to follow these 5 judges and 2-3 judges benches, Milord. I do not consider those to be a good judgment because 5 judges would prevail. Today, your lordship, Milord, is having Pranay Sethi, which says, Milord, one typical methodology. And one honorable division bench of Supreme Court, Milord, comes up and says that, no, we think that something more should be given. Milord, in my humble submission, Milord, as far as...
No,
Milord,
after considering this Pranay Sethi.
Yes, even if one division bench says that no.
Whether, while, unless you see this is considered, then that becomes per incurium.
I'm extremely grateful.
So if this Sarola Verma, this Pranay Sethi is considered and then judgment is delivered very well.
No, Milord, a division bench.
Yes.
How can, Milord, it differ from a 5 judges bench? This is where I join issues.
Question is, if
Lordship.
the division bench, you see,
Lordship.
gives the reasons
Lordship.
as to what these are the grounds where we can differ or these are the exceptions, then we have to consider that also.
No, Milord, I'll be addressing your lordship on those particular point also.
Yes.
Because, Milord, every division bench or every 3 judges bench, Milord, there are 15, 20 judgments or maybe more, which differ from Pranay Sethi on the point of, Milord, certain quantification.
Because you see, Pranay Sethi is referred to all high courts and Supreme Court.
Yes.
Upon considering Pranay Sethi, all judges have to come to the conclusion.
Yes.
On the facts of the case.
Lordship.
Because
No,
courts-
Milord, Lordship, kindly pardon me. Milord, kindly pardon.
On the quantum of calculation.
On the quantum of calculation, Milord,
Yes.
when Pranay Sethi, 5 judges say that, Milord, for this age group, multiplier should be X. Milord, my difficulty is if another division bench comes up or a 3 judges bench comes up and says that, no, we will not, for this particular age group, we will not say X multiplier, we would use Y multiplier. Milord, today as a council, Milord, what do I do? Pranay Sethi is specifying one thing, 5 judges, a division bench comes up, they come up every other day and they say that, no, we will not follow Pranay Singh on this particular point. If you do not follow, Milord, the law says you refer it before the Chief Justice.
That is very well known to the courts. Okay, what is to be done? But
Milord,
what happens? Some clarification is given, some point is accepted. Now what will be the things to be followed?
Milord, in my humble submission, Pranay Sethi, Milord, as the law as stands today, Honorable 5 judges
So,
bench sat together.
considering some decisions, if the Supreme Court decides otherwise,
Lordship.
whatever it is there,
Milord, the difficulty is if my lord judgment today is not considered by tribunal and tribunal says
if it is upon considering the same,
this would be a judicial anarchy. Lordship will kindly pardon me. When 5 judges have decided one particular issue, that issue is specific. It is, Milord, calculation is specific. Then a subordinate, Milord, I would not call it subordinate court, a division bench or even a 3 judges bench, Milord, if it differs from the 5 judges, your lordship, Milord, knows more than me. I did not trouble your lordship, Milord. They should refer the matter. The matter should go to a bench, Milord, of having at least the equal strength of 5 judges or more than that.
That is the law.
That is the law.
Now the question is, if the circumstances differ, okay. If there are certain grounds,
Lordship, if circumstances differ, Milord, then your lordship will see those, Milord. Milord, Milord, your lordship will kindly come, Milord, to the Pranay Sethi, the last but one page.
Last paragraph.
Yes, Milord, paragraph 61, last but one page. Milord, this is the conclusion. Paragraph 61 is, my lord, there?
Yes.
In view of the aforesaid, Milord, this has dealt with the entire analysis of Sarla Verma and all other cases. This is of, Milord, October 2017.
Yes.
Pranay Sethi. And it has been given retrospective effect. All matters pending before today, your lordship, my lord, or even before the learned tribunal are following this penalty. So, my lord, one thing is clear. My lord, the two judges bench of Santosh Devi should have been well advised to refer the matter to a larger bench, as it was taking a different view. My lord, I'm at 61-1, lordship. And it was taking a different view than what has been stated in Sarla Verma, a judgment by a coordinate bench. It is because a coordinate bench of the same strength cannot take a contrary. My lord, the same strength, even the coordinate bench cannot take a contrary view. My lord, I was talking about the 5 judges bench.
Yes.
Contrary view that what has been held by another coordinate bench. Aye. As Rajesh, my lord, Rajesh is a judgment. Rajesh versus Rajveer. As Rajesh has not taken note of the decision in Reshma Kumari, which was delivered at earlier point of time, the decision in Rajesh is not binding precedent. My lord, kindly take a note of that. My lord, both were 3 judges bench. Rajesh, my lord, was subsequent. Reshma Kumari was earlier. My lord, earlier bench judgment was not considered in the proper aspect. So, my lord, this is not a good judgment. While determining the income, an addition of 50% of actual salary to the income of the deceased towards future prospect, where the deceased had a permanent job and was below the age of 40 years. My lord, this, it has differed from Sarla Verma. It has, my lord, improved on Sarla Verma. Should be made. The addition should be 30% if the age of the deceased was between 40 to 50 years. In case the deceased was between the 50 to 60 years, the addition be 15%. Actual salary should be read as actual salary less tax. 4. In case the deceased was self-employed or on a fixed salary, an addition of 40% of the established income should be warranted where the deceased was below the age of 40 years, addition of 25% where the deceased was between the age of 40 to 50 years, and 10% where the deceased was between 50 to 60 years should be regarded as necessary method of computation. The established income means income minus the tax component. 5. For determination of the multiplicand, the deduction for personal and living expenses, the tribunals and courts shall be guided by paragraph 30 to 32 of Sarla Verma. My lord, I have forwarded to your Sarla Verma to your lordship. The selection of multiplier shall be as indicated in the table Sarla Verma with paragraph 42. So, my lord, Sarla Verma was taken note of, and it said that we will follow Sarla Verma. The age of the deceased, my lord, should be the basis for applying the multiplier. And, my lord, the last one, 8, reasonable figures on conventional heads, namely loss of estate, loss of consortium. My lord, consortium issue was raised before your lordship, my lord, today.
Yes.
And funeral expenses should be, my lord, your lordship will kindly take note, should be. 5 judges bench says should be. 15, 40, and 15 respectively. The aforesaid amount should be enhanced at the rate of 10% in every 3 years. My lord, now, on the basis of this, আমার কাগজগুলো কোথায় গেল জাজমেন্ট গুলো
একটা কপিতে জজকে দিয়েছি
Milord, in the judgment, Milord, in the judgment, what I have given to your lordship, Milord, is there any green page, Milord?
Yes.
Green full escape pages, Milord, is there any? Because I had prepared a chart for my lord's consideration. There is none, no, Milord. It must have been here, it was here. That's Sobuj Pata. Milord, Milord, I'm sorry, Milord. On the basis of planacity, Milord, for my lord's consideration, Milord, I have prepared a chart. It's a ready reckoner. Your lordship will kindly have a look, Milord. I'll take 2 minutes of my lord's time. Milord, this is the combined outcome of Sarla Verma and Pranay-Sethi. Milord, number 1 is income. Milord, what we had been doing, Milord, now there are certain disputes, Milord, with regard to, Milord, there are so many cases before your lordship, when, Milord, the income of the victim is not proved. So many cases, neither the income nor the employment. Milord, for the last so many years, Milord, when the cases where the victim's income was not proved, Milord, we, on this side of the bar, Milord, we had come to an understanding that for up to this year, we will follow this income so that honorable court would not be troubled and, Milord, the matters can be disposed of on quantum. Milord, up to the year 2010. Milord, I say that I'm a mason, I'm a rickshaw.
That is the division bench presided in the Honorable Supreme Court by Justice S.B. Sinha. That 3,000 was at the very initial stage.
Extremely grateful. 2009 judgment.
Yes, Justice S.B. Sinha's judgment.
I'm extremely, Milord, Mohammed Devi, Mohammed Tabar. I'm obliged to your lordship. Milord,
Justice Sinha and Justice Sidpurkar.
Yes. Milord, therein, Milord, what used to happen, Milord, as I stated earlier, statute says 15,000 rupees per annum. Section 163, capital A, Act of 1994. Milord, my learned friend's client, Milord, comes up before the court and says that I was a mason. no documents, no evidence of income. So, my lord, till then, till Justice Sinha's judgment, what used to happen? Court used to consider the income at 15,000 rupees per annum.
Right.
So, my lord, there in 2009, that Lakshmi Devi Mohammed Abba, what my lord is referring, Justice Sinha said that no, at least 100 rupees a day we can consider. They don't have their poor fellow from the lower strata of society. They cannot show their income. So, I will take it 100 rupees a day. So, that, my lord, then it became a norm that at least if they can't prove, take it 100 rupees a day. But there also, my lord, the Honorable Court said that we are increasing the income from 15,000 to 36,000 per annum. We are reducing the multiplier by 2. Multiplier was reduced, my lord, from 16 to 14 or 15 to 13 to balance out. But, my lord, still, be that as it may, 100 rupees per day was, my lord, taken as a norm. So that is why, my lord, up to the year 2010, my lord, kindly sees, my lord, I have said that whatever the income was, if it was not proved, my lord will take it at the rate of 2,000 rupees per month and will not dispose of the appeal. Insurance companies on this side would not object. They will not argue that no income, 15,000 rupees, the statute says this, that. Up to, my lord, 11 to 14, my lord, we had conceded. Insurance company conceded, no documents, nothing, take 4,000, go away. Not up to 2015, from 15 onwards, we had considered on our part that take 5,000 rupees. I mean, on this calculation, the charts what have been made for the last 7-8 years, if not more than 1,000 appeal has been, if not more, have been disposed of by this Honorable Court. Now we are in 2025. The claimants are saying, I must indicate, the Supreme Court says that take the Minimum Wages Act. If you prove your vocation, take Minimum Wages Act, and so many appeals are being now disposed of on that Minimum Wages Act as well. But there are certain conditions, you have to show that yes, you are what you were claiming. Income cannot be proved. So minimum wages is, nowadays it is coming up, so it is being tweaked. But as far as the earlier years are concerned, on this basis, for my lord's consideration, I have given this. And on this basis, I can say here that more than 1,000 appeals have been disposed of on the basis of this particular chart and this particular figure. And half of them by Honorable Division Bench, presided over by Honorable Justice Dipankar Tattva, presided over by Honorable Justice Sanjeev Banerjee, presided over by Honorable Justice Somapti Chatterjee, presided over by Honorable Justice Harish Tandon. I just gave a few names. All these division benches, and forget about Honorable single benches. Number 2 is multiplier. This is is following Pranay Sethi. It's a ready reckoner, whenever my lord gets any amount, your lord any age group, your lordship will see this multiplier would be followed. Number 3 is future prospect. What my learned friend was taking an hour, this is a matter of seconds. Your lordship will see this reckoner, and your lordship will decide what the future prospect would be in each individual death case, or for that matter, even in an injury case. This is followed in both. 4 is deduction for personal expenses. This has also been explained to your lordship, When the bachelor was there, it is 50%. And what my lord was saying, 1/3. When the number of dependent claimants are 1 to 3, 1/3. When the number of dependent claimants are 4 to 6, 1/4. And when it exceeds 6, it should be 1/5. And 163A. There has been a Supreme Court judgment wherein this has become 5 lakh in case of death. This now
no fault liability.
No fault liability. No fault liability. There were 2 no fault liabilities. One was under section 140, which was interim.
No, that was by the vehicle owner. 140,
No,
the
no,
liability was. No, that is also a no fault liability. 163A is also a no fault liability.
Lordship. After 140, 140 was immediate and interim relief. The claimant would go for 140. They would, in case of death, they would get 50,000, injury 25,000, and then they go to 166 for the final compensation. But in 163A is a one and single compensation. You come to the court only once. It was when in 1994 it was introduced. It was for the lower strata of society.
Yes, low income group.
Lower income group. I'm grateful to your lordship. Those who had the maximum income of rupees 40,000 per annum, that was the ceiling. If your income is 40,000 rupees per annum, and if you want to take advantage of 163A, you do not have to prove the fault. As my lord said, no fault liability. Come to the court, just prove the accident. Simpliciter accident and policy coverage, and go away with 5 lakhs. But it was not for those poor people, so that they don't have to run around, and this cost of litigation is saved. Right. So this ready reckoner, your lordship, would help my lord. Sarla Verma and Pranay Sethi I have given to your lordship. Pranay Sethi, my lord, the last paragraph, the penultimate, my lord, is
Yes.
my lord, giving the details, my lord, what to be followed, and it's a 5 judges bench. That is, my lord, the gospel now. Last word as far as the Motor Vehicle Act is concerned. If any particular issue which was not touched by Pranay Sethi, and if that comes up subsequently, my lord, we bow down to that. But the issue if the issue has been touched and decided by Pranay Sethi, my lord, we pray before your lordship, my lord, no further tweaking should be done unless it is referred to a larger bench. My lord, now coming back to this particular case of my learned friend. My lord, as far as my part of award is concerned, which was at page number, my lord, 42, 43. My lord has seen that, my lord, of this paper book. 11 lakhs 60,323. My lord, be kind enough, my lord, to come to page number 42.
42.
Lordship. The last paragraph, and thereafter, my lord, at page 43.
Yes.
Page 43, my lord. Second paragraph, accordingly, is my lord there, my lord. Owners and insurers of vehicle number 3171 are jointly and severally liable to pay 11 lakhs odd. But I am 3171. I have paid my share with interest. Now, my lord, on enhancement part. Lord, I am not getting into my learned friend's share. I have already stated it's for my lord to decide, my lord, whether the right to recovery would be granted or not.
No, with regard to enhancement, whether Pranay Sethi has been followed by the learned court.
My lord, where it has not been followed, my lord, I am just indicating to those. My lord, monthly income, that was the first bone of contention, my lord, on my part. My lord, one particular salary slip has been shown before the learned tribunal. This is where I say that the claimants, my lord, it is at, may I invite my lord to page 81 and 82, was shown to your lordship.
'81 of the paper book.
81 of the paper book. Grateful to your lordship.
Yes, 81.
My lord, 81, and my lord, the specific certificate is at 82. Both are, my lord, of December 2009. Victim died, my lord, in January 2010. So this is the last pay slip. My lord, on the basis of this pay slip,
yes,
the gross salary, my lord, of 30691 was taken into consideration.
Yes.
My lord, my learned friend, on behalf of the claimant, my lord, is partly right in saying that 150 rupees should be deducted from professional tax. He is arguing against himself. I am thankful to him for being truthful to this extent. But, my lord, your lordship will kindly see, year was 2009. One single salary slip was shown to the court. This is subterfuge. This is what I call, my lord, deliberately, knowingly, my lord, income tax part has not been reflected in one salary sheet, and you have shown one single salary slip. Why did not you bring the entire year's? My lord, yearly income, my lord, is rupees 3,68,242. My lord, this calculation is there at page 42, 43.
Yes, which page that is?
My lord, page number, if my reading goes correct, my lord, kindly come to page number 4040. Or rather, my lord, it's specifically as page 39. May I invite my lord to page 39 of this paper book? Page 39, my lord, last paragraph.
Yes.
My lord, your lordship will kindly see, in a motor case, gross salary of the deceased is considered as his income. Accordingly, yearly income of the deceased, taking 30691 is 368,292. Am I clear to your lordship?
Yes, yes.
My lord, out of this 368292, or my lord, this 30691, my lord, this calculation is correct. There is no dispute.
Yes.
My lord, this my lord has seen at page 39 bottom, my lord, monthly income,
Yes.
my lord, and the annual income 30691, and as rightly pointed out by my learned friend, 150 deducted. So the chart what he has given to your lordship, after deduction of 150, my lord, net income is shown as 30541. Up to that extent it is correct. But my lord, I join issues here. Where is the income tax deduction? In 1 month salary slip, there was no deduction shown. But my lord, this is issued by my lord, the West Bengal department, government department. But my lord, every single month, my lord, income tax is not deducted in so many organizations. Somewhere it is quarterly, somewhere it is half yearly, somewhere it is annually. My lord, when I take, my lord, the Income Tax Act for the year 2009-10, my lord, I'll show it to your lordship, my lord, that in 2009-10, my lord, it is 15 years from now. My lord, 1,60,000, my lord, was tax-free income, 160. Up to 1,60,000, my lord, there was no tax. And my lord, from 1,60,000 to 3 lakhs,
Now here the deduction is PT, professional tax.
only professional tax. What about income tax deduction? I asked this question to myself.
Income tax
My lord,
definitely.
Indira Srivastava, my lord, judgment was shown by my learned friend.
Yes, yes.
It is very clear that tax deduction has to be done. And if the
No, let your learned friend complete.
My learned friend has not preferred any cross appeal.
No,
He is
with regard to enhancement, he is arguing with regard to.
He is debarred from Mother to argue that point.
Yes, let
regarding
us.
the income tax.
You see, the court has to consider the entire thing. Okay, not only one issue.
If so,
Anyway, you complete, please.
everything on oral submission.
my lord, this ridiculous and absurd statements are being made before the court. I do not know how long he has been practicing. He's there for 35 years. He is asking money from me in appeal. And he's saying that I can't argue. Don't ask money from me.
That would be decided by your lordship. Whether my client.
Anyway, let him take his own stand.
Without cross appeal, anything,
No, you have also prayed for enhancement. Okay.
enhancement 15% he has considered.
No.
As for the pronunciative, 15%.
Whatever it is, he has accepted, your learned friend has accepted the trial court's judgment. Now you want an enhancement.
Has accepted by my learned.
Very well, now you want an enhancement of that.
Yes.
So it will fall upon him also.
Enhancement he can argue.
Whatever it is, he has to give the entire picture.
Without finding any cross appeal or cross objection.
Anyway, you see, he cannot confine to a particular argument.
It's not a statutory point.
No. Let him clear the entire picture. Yes, you conclude, please.
I'm sorry, I'm sorry for him as well.
Every code income tax.
My lord, as I was indicating to your lordship, my lord, up to 1,60,000, my lord, it was tax-free income. From 1,60,000 to 3 lakhs, my lord, the tax was 10%, 10. And my lord, from 3 lakhs to 5 lakhs, my lord, it was 20%. So, my lord, if I take that into, my lord, the only thing what I said before your lordship, one comes to the court asking for compensation in terms of money. That X has died, now give me money. If you want money, then you come with the clean hands. That yes, this was his income, this was his tax payment, and this was his net income, this was the loss of dependency. Make calculation, take the money, no issues. My lord, 11 lakhs I have already paid, my lord. I wouldn't have argued this case had this enhancement point not being come up before your lordship. I was not here. But he says that no, I will not pay income tax. Now, on the basis of 1 month salary slip, which does not reflect the income tax, you make the entire calculation and accordingly now you make payment.
Anyway,
Milord,
this point was taken before the trial court.
Milord, this point need not be taken. This is for the Honorable Court, Milord, and the learned tribunal just to see to it that whether the assessment is being made correctly or not.
Because
Milord, income tax, Milord,
the authorities was before the court.
No,
Okay.
but this Indira Srivastava was also not there before the court.
No, question.
Milord,
No.
Today, when my lord is enhancing, today, when my lord is considering, your lordship, Milord, your lordship will kindly have a look at this, that whether it is just or not. Milord, I'm not on the calculation part. X multiplied by 12, Planas it is said. X deduction 1/3, 1/4, Planas it is said. But X, what was your exact income? Your lordship has to see that. On the basis of which, Milord, that becomes the principal base on the basis of which entire compensation is to be made. Today he says that your lordship will kindly take X as my base. And I say that when X was your base, where is the income tax payment on X? He says, no, I'm not required. The statute is very specific. Income tax is to be deducted. The judgment, what he had shown to your lordship, and it is not clear. Your net income should be considered. I'm not on your GPF. I'm not on your other deposits. Yes, you are entitled, because that was the actual loss of dependency of the claimants. But the tax the claimants were not getting. Tax was going to the government.
Right.
Why do you say that, no, give me my money on tax also? It should not be. Your dependents were not getting the tax amount, income
Not
tax amount.
deducted at source at the time of filing the return.
At the time of filing of return.
Either way.
Either way.
If it is taxable, if not deducted at source, at the time of filing of the return.
Lordship, Milord, return is not here before your lordship. They should have. At least if not, then Milord, in all fairness, they should have given 12 months salary slip. If in entire 12 months, no reflection of income tax was there, I wouldn't have been here before your lordship arguing this point. You give 1 month salary slip. In 1 month, tax deduction is not shown.
Any question was put in cross-examination? How much income tax do you pay in the year?
No.
Anyway, you go on.
Milord, even if it was not there, Milord, are they not supposed to pay income tax?
No,
Because
sir.
Income Tax Act is very clear. I have shown.
Whatever it is, if nothing is clear, you see, you have to put all these questions in cross-examination.
Milord, one would come up, Milord, with Milord, this dirty hands before the court, and Milord, run away with the money.
Whatever it is, you
Milord,
see,
my lord today is deciding, Lord, what is just. And your lordship will say that since you did not ask for the income tax, let them get advantage of income tax.
Question
I
is-
put this question to myself.
question is, you see, after so many years, you see,
Yes.
these questions are coming.
But Milord,
They-
after so many
they-
years, he is coming
they-
for enhancement.
That is a different issue, okay, but whether the court will,
My question is attached to his enhancement.
yes, that will be
And-
considered.
Couldn't have been troubling your lordship. I have paid my share. You asked for enhancement and you said that no, income tax was not required to be paid. Whereas the statute is very clear. Even today you show it. I'll be out of court.
Yes.
You show it today if you are so clean. I'm showing the statute that you were liable to pay income tax. You pay 1 month salary slip.
Let them take leave and produce.
Milord, your lordship will kindly say, Milord, no fraud is committed before the court. Even
Anyway,
assuming, Milord, even assuming I was not here. Milord, let me.
now
take
you
over-
see, for these professional persons and all these things, these income tax returns are filed. This is the usual procedure.
No,
in-
all service holders.
No. But you see, for government person, usually you see, court relies upon this salary slips. With regard to income tax and all these things, if these questions are put in cross-examination, very well, he has to answer that. So in this professional persons, income tax return, what is the procedure which is followed? Income tax with regard to this salaried persons, that last pay slip is seen, unless a question comes that yes, with regard to income tax, how much it is paid. When these questions come, that is the procedure which is followed.
This is statutory liability upon an individual. My lord is deciding what was your net income. Net income, my lord. Net income, the judgment, and my lord, all Supreme Court are, my lord, very clear. Net income means, my lord, statutory payment of tax has to be deducted. In this case, income tax, which, my lord, the tax, otherwise the statute shows, my lord, this was your liability. You say that if it was not my liability, my lord, today you are in for enhancement. For this 27 or 29 lakhs, my lord, there was no issue. I have decided, I have paid. But now you come up for enhancement, then you show that yes, you were entitled to. My lord is here, my lord, to decide that yes, my lord, one should be very clean before my lord, before coming for asking for enhancement or even asking for compensation. I would never stand in the way. You show and you take. If you ask for more, you take more. Even today you come up with an additional evidence, the salary was not 31,000, 35,000. You show that. Why shall I be arguing? But it should be just. And it should be, my lord, clear. My lord, justice, my lord, should also be seen to be delivered, my lord, in just way, my lord. Your lordship will kindly, my lord, just because one particular question with regard to income tax was not there, assuming it was not there, my lord, I have not gone into those, my lord. It does not mean that you would run away with the tax part.
Why this court will open this factual aspect? Anyway, you just
My lord,
argue.
if court is asking for the enhancement, if
Let us see how much you will be entitled to enhancement.
Lordship. My lord, this was one part. As far as, my lord, the income part is concerned, my lord, he said that, and my lord, as far as the second part, which not this in this case, learned tribunal, my lord, your lordship will kindly come to page number 82, my lord. My lord, I'm sorry.
Yes.
My lord, he gets the deceased, my lord, or the claimants get the advantage of every individual head. Your lordship will kindly say, my lord, basic pay, grade pay, DNS allowance, house rent allowance, medical allowance, ration allowance, risk allowance. My lord, I do not know, my lord, this risk allowance.
Actually, you see, this
My lord,
police authorities get 13 months salary also. But anyway, this is not considered.
my lord, that is not here.
Anyway, this is not yearly income is 13 months salary.
My lord, I am not, my lord, even on the GPF on the right side, GI 7 except professional tax, my lord, I am not disputing any of the heads. I don't say, but my lord, I say, what is your statutory liability? Please show that. Please comply with that. And then you make calculation. He himself said that, yes, I'm liable to pay tax. And then he says that, no, for enhancement and before your lordship, I will not show. I don't have, my lord, whatever the reasons are, my lord, this is why I say, my lord, it is subterfuge. You don't come up with clean hands before the court. And then, my lord, even in appellate court, you continue with that. Your lordship, my lord, if a wrong has been committed, your lordship will kindly not allow that wrong to be continued before my lord. This is what I humbly submit, my lord. My lord, 1 lakh here and there would not make any difference. But my lord, this system of continuing with the wrong, your lordship will kindly not permit. If they are entitled, my lord, whatever they are entitled, my lord, nowadays compensation are in crores. They are getting. You come, you show, and then you take it. But don't mislead. This is what I submitted with it. My lord, this was the income aspect. My lord, your lordship will kindly take note of that. My lord, I have given your lordship, my lord, indicated the chart, what they were supposed to pay. If they pay that, your lordship will make calculation. If they get, my lord, if any amount is to be given back to insurance company, my lord, I submit before your lordship, I will not ask for that. I will not ask. I have paid, my lord, I will not ask for the refund. But if enhancement, my lord, if it is not entitled to, then they should not get. You know, now coming to this Sarla Verma and Pranay Sethi, this your lordship will kindly see 84, the chart of my learned friend. If may I invite your lordship to that.
Yes. You have given your own chart.
No, my lord, I have not given any chart.
No, this one. Oh, this is the.
My lord, this is my lord's.
This is the principle let down.
This is the reckoner minute for my lord's convenience. Because every time my lord doesn't have to open up, my lord, this Sarla Verma, Pranay Sethi, the book, and what is the number, what is the multiplier, what is the deduction. This would help your lordship in every individual case. My lord, my learned friend's chart, my lord, what was given to your lordship. My lord, this 84,000 general damages. My lord, now, my lord, I had shown to your lordship, my lord, in the Pranay Sethis, that penultimate paragraph, number 7, item, my lord, it is 40, 70,000. And my lord, the last line says, every 3 years.
Okay, 70,000.
70. My lord, this is, my lord, 15 for funeral, 15 for, my lord, the loss of estate, and 40 consortium. My lord, consortium, the honorable 5 judges have discussed at length, and that said, my lord, and they came to the finding, this consortium should be confined to spousal consortium only. This consortium should not be given to the children, to the parents, to the brothers, sisters.
So quantum should be calculated accordingly.
Accordingly. This is not because a point was raised with regard to the consortium as well. My lord, Pranay Sethi, when 5 judges sat together, and they said the consortium should be confined to spousal.
Only the widow.
Only the widow, or my lord, if the
is a widower.
The widower. So it should not be expanded. Nowadays, my lord, Supreme Court, several judgments, my lord, are coming up. They are expanding the meaning.
Now, at the time of compensation, this should be taken into
This
consideration.
should be taken into consideration.
Regarding the quantum.
Regarding the quantum, my lord. With that methodology, my lord, that calculation part, my lord, I have given. My lord, now this 84,000 what my learned friend has prayed for, my lord, this is on the basis, my lord, on the point number 7 of paragraph number 61 of Pranay Sethi. If my lord kindly comes, my lord, just for a moment. Pranay Sethi, my lord.
Page 61.
My lord, paragraph 61, my lord, last but one page of Pranay Sethi. Last point. Now point 8, my lord, Roman 8, small. Page 60, my lord, paragraph 61, last
Roman 8.
Lordship will kindly say, my lord. Reasonable figures on conventional heads, namely loss of estate, loss of consortium, and funeral expenses should be 15, 40, and 15. That is 70,000, my lord. General damages clubbed together. Then, my lord, the last line. The aforesaid amount should be enhanced at the rate of 10% in every 3 years. So, my lord, this is the judgment of your lordship sees October 21.
2017.
2017, right. So, my lord, 2017 to October 2020, my lord, this conventional head should be remaining 70,000, 3 years. And from, my lord, November 2020.
Up to 2020, it will remain this.
I'm grateful to your lordship.
Thereafter, 2020 to 2023.
No.
2000.
One thing, my lord, when the judgment was pronounced in November 2017. Thereafter, my lord, the 3 year, 10% will be increased. That is, my lord, in the year 2020, it should be 77,000. And in the year 2023, it should be 20,000. Now, your lordship deciding the case in the year 2020.
No, what basis that will?
Yes, that was, my lord, the paragraph 52.
No, this is the aforesaid amount should be enhanced at the rate of 10% in every 3 years.
Every 3 years. So
uniformly every 3 years.
Unnecessary, my lord, this disturbances. This is not done in High Court.
My lord, the judgment was pronounced, my lord, November or September 2017. Thereafter 3 years, my lord, if it is passed, then it comes, my lord, in the year 2020. So 10% should be increased. So 17,000 should be increased in 77,000. And thereafter, after 3 years, my lord, 2023, that should be, my lord, 84,000, 7,000 more at 84,000. So, my lord, today your lordship is deciding is, my lord, in the year 2025. So, my lord, I confine that 84,000.
Anyway, yes.
This is very unfortunate.
Unfortunate.
Yes, so this is 84,000, yes?
No, my lord, it cannot be. This is what I was trying to indicate to your lordship. My lord, October 2017, judgment was passed. It said 70,000. Next enhancement, my lord, would be in November 2020. After 3 years, it would be 77,000. If you have got money before November 2020, then it would be confined to 70,000.
Yes.
My lord, when did the award was passed? 2017. I have paid my share of money. How come he's asking for enhancement? You've got the money, and now he's saying that no, a continuation of proceeding. I got the money, 70,000. Now it is continuation of proceeding. So I will take advantage. This is subterfuge. This is again a cheat. You got your money of 70,000 in 2017, or even 18, or 19, or even for that matter 20.
He got 2 lakhs.
Then, my lord, now you come up and say that no, now give me more.
Anyway, but the question is,
Lordship,
the learned judge considered the damages as 1 lakh. On the basis of
general
that 1 lakh,
damages, general damages 2 lakh granted.
2 lakhs. So on that he has obtained.
Yes, my lord, that he has obtained. Now 70,000 is a part of that 2 lakhs.
Yes, whatever
Yes,
it is,
what's that?
in not 84,000, the court granted about 2 lakh.
Not 70,000.
No, it's 84,000. According to your learned friend, it is.
According to my learned friend,
it is 84,000.
Yes.
But how much the court granted? This
2 lakhs.
2 lakhs.
2 lakhs.
So it is not that the court has granted less.
So, my lord, this is what I was trying to indicate. My lord, up to 2020, if you have got the money then there is no question of any enhancement under general damages.
No, 2 lakh paid already 2 lakh.
So I'm extremely grateful, my lord. I would not be arguing any further on this particular issue.
Yes.
So, my lord, income tax part, if your lordship will kindly take note of this, and this general damages, my lord, this 70,000 is to be taken, my lord, your lordship will kindly, because, my lord, I do not know what papers he keeps on submitting to your lordship. Every paper, my lord, has a different calculation.
So your according to you, it
My
could
lord.
be 77,000 and yes,
70.
70.
Because it was 2017 award.
And you have paid
So
that in
award was passed is Bernard.
2017, yes.
2017.
And you have paid in 2017 itself.
My lord, appeal is
Even
a
if assuming
continuation.
2018, up to 2020, I am covered.
My lord, your lordship is deciding the case in the year 2025.
And is he refunding back the money to me? Yes, I will pay. Let him refund back the money with interest to me. I'll pay today.
My lord, it is well said to principle.
I have to see whether the learned judge erred in awarding that damages. Okay. If the learned judge has erred, he has awarded less, then the court will award the excess. But if the learned judge has not committed any error, on the other hand, has awarded 2 lakh instead of 84,000.
Out of 2 lakhs added, my lord, they have satisfied only 40%. Not my
Whatever it is, whatever the court has awarded, that they have satisfied.
They are satisfied because they know that if it is appeal, my lord,
How they will know?
for that, my lord, he has not preferred any cross appeal.
Very well, very well. Now this matter comes to an end. This 84,000. Yes. Any other point?
But this 84,000 should be brought down to 70,000. That's what they are entitled to. 70. This is the total compensation calculation. What they are in actual entitled to in law. So this 84,000 should be brought down to 70,000 they are entitled to in law.
Now, only question is this future prospect.
The
Okay.
future prospect is, as per penalty, they are entitled for 15%. There is no dispute, my lord. I say that. But whatever they are legally entitled to, absolutely no confusion.
No, regarding future prospect, the learned trial court has not taken this future
But
prospect.
they should get. I say that.
Future prospect into
today,
consideration.
Today, my lord is calculating afresh. My lord, let me put it this way. Today, in 2025, your lordship, taking note of Pranay Sethi, Sarla Verma read together, is making the correct calculation, what he is otherwise entitled to. So, my lord, today he is entitled for 15%. As I said, my lord, Pranay Sethi has been given retrospective effect. So, he will get, my lord, I am not standing in his way. Whatever he is legally entitled to, he should get. 15% he should get. 6% interest he should get. My lord, he should also get, my lord, this general damages. But, my lord, what is correct, he should get that.
Yes.
My lord, award of 2017, Pranay Sethi said, up to 2020, you will get 70,000. He says, no. Today's 2025, I'm getting money today. If you are getting money today, absolutely correct. I agree with you. You give me back my money with interest. I will give you today again. Let him agree to that. You took the money, you enjoyed it, and now you say, no, I'm in appeal, so give me more. Just for being in appeal, give me more should not be there. So the money what I gave you, you give back to me. And then I'll bow down to your lordship. Then your lordship will grant 84,000 today because he has not received any money. If he has received the money, he has enjoyed its fruit, and then he says, give me more, this should not be permissible. And your lordship will please take note of, my lord, this income tax, let it be deducted, let a fresh calculation be made, and if he is entitled for anything more, my lord, he will get. If not, then, my lord, I submit before your lordship, I will not ask for the refund.
Yes. Anything you want to reply?
Extremely grateful to
My lord, only thing, my lord, that the appeal preferred by the Reliance Insurance Company, my lord, this appeal is not preferred by the, my lord, the Royal Sundaram. Royal Sundaram accepted everything. That was, my lord, the income accepted by the trial court.
You have also accepted the compensation.
Yes.
Only, my lord, I have accepted the TK amount, only, my lord, 11 lakh. And the, my lord, the award was passed, my lord, is 26 lakh. 17 lakhs, my lord, that the Reliance, my lord, is casted upon Reliance, that was not given. They preferred the appeal. Now, my lord, I made a cross appeal because following the decisions ratio decided by the, my lord, the Pranay Sethi, the 15%
After 6 years.
posted did not, my lord, has not been considered. And, my lord, the interest part, and I also, my lord, as a good, my lord, as
interest part you forgo.
I considered that the London Tribunal was wrong in considering the Mala Tula as general damages, it should be 84,000. As per
So
the
that is
provision.
there, so that stand is there, as well as the learned tribunal did not consider the future prospect as per the pronunciation.
And also the general damages, the
General damages goes against you, and so far the,
future prospect.
but future prospect goes in your favor.
Future prospect should be considered as per the.
So if it is considered, it will go in your favor. But so far the general damages is considered, it will go against you.
But the general damage, my lord, to some extent, I am entitled 84,000.
Very
That
well.
is my submission.
My lord, regarding the income tax, it has to be deducted since my lord is calculating the award fresh. So this should be, I mean, maybe considered by my lord, because in 2009, as my
See,
learned friend,
this 150 is concerned, 150 is apparent on the face of the record. There is no dispute with regard to that. That 150,
Professional tax.
yes, that is
Professional.
on the face of the record. That cannot be
my
ignored.
lord can also direct
Now-
my learned friend to produce some in
Now the question is how much it comes if 150 is ignored. Whatever the learned trial judge has calculated, suppose this 150 is ignored, how much it comes? You give the calculation.
total
So-
deduction 1158 has to be done then.
No, question is professional tax has to be deducted. It is apparent on the face of the record.
30541.
Yes.
That means
The chart of my learned friend after
Yes.
deducting 150,
After considering
I have,
30541.
30541.
Yes.
That is the monthly.
Monthly.
So 150 is deducted. 150 is deducted. That means you see yearly comes to how much?
3,66,492. That has been calculated by my learned friend. And future prospect
That means
is
1800 less 1800. It should be 1800 less.
Yes. Yearly.
yes.
Yearly 1800 less.
that
And-
I have calculated by.
That
And if 1800 is less,
yes.
we go by whatever the learned judge has calculated. This 150 is error apparent on the face of the record. Suppose this 150 is taken into consideration, 1800 less annual income.
The learned tribunal judge has not by law deducted professional tax.
No, that is why I am saying.
What he is saying.
That is 1800 would fall in your yearly income. And if 1800 falls, how much?
I mean that.
So 1800 less, whatever is your, how much was your yearly income? 3 lakh something.
Yes.
And
3,66,000 that was given in my chart. Father.
3,66,000.
জাজমেন্টে কি আছে সেটা জানতে চাই।
My lord, yearly income.
No, yearly income the court has followed, accepted your monthly income
My lord,
without
from 3,68,000 odd. It has come down, my lord, after deduction of, my lord, 1,800, 3,66,000. Only 1,800 rupees is deducted yearly.
So 3,66,000, the judge has proceeded on 3,66,000.
368, because judge did not deduct professional
So that
tax.
3,66,000, if that is his yearly income, then
Without
he-
payment of income tax.
no, I shall go by the record. I
Your
don't know.
lordship will not- your
I
lordship will
shall-
take note of income
No, I
tax.
shall consider a submission. What is apparent on the face of the
No, it
record?
is apparent
There
because
is no evidence with regard to income tax, no question. Anyway, it is simply submission from the bar. So maybe now the question is, what is there in the professional tax is 150.
150.
My lord, the annual income as computed by the learned tribunal is 3 lakhs
68,000.
68,000, and here after deducting 150 it comes to 3,66,000. Yes, and this
So if
15%
So if 3,66,000 is proceeded with, how much it comes?
with 15% দাঁড়াও বলছি 15% future prospect if added according to pronunciation it comes to plus 54,974. It total comes to 4,21,466. To this 1/3 deduction has to be made, which comes to again 2,80,978, and multiplier of 11, then it totally comes to 30,90,758. And after adding general damages, my learned friend has added 84,000, but it will be 70,000.
No, add the 2 lakh, whatever is added by the learned trial judge. You see, learned trial.
Why? It is a fresh
Okay,
calculation.
calculation. Yes, yes. Then how much?
Yes, sir. It will be 70,000, my lord, according to, because it was 2017 judgment of the learned tribunal, and according to it, 70,000 will be added. You have preferred this appeal, I mean court, after 6 long years
Now
of my appeal.
now the question comes, how much? Now the calculation comes to?
Comes to, my lord, 8, 5, 7.
14,000 banner be.
হ্যাঁ, ওটা 14,000 ডিডাক্ট করে কত হচ্ছে বলো? 8। হ্যাঁ, তা ইন্টারেস্টটা যখন পড়বে তখন কি হবে? তুমিও 14,000 টাকা ছেড়ে দাও।
একটা ফ্ল্যাশ ক্যালকুলেশন করে জজ সাহেবকে দিয়ে
হ্যাঁ, আমি দিয়ে দিচ্ছি। And my lord, we have, my lord, kindly consider the fact we have deposited 25,52,852.
That is inclusive of interest.
Yes, we have already deposited.
Anyway, it's better.
And
Both of your learned friends has given their chart and calculation. You give your chart.
my lord, and the principal amount will be in such a way that the 40% will be satisfied by my learned senior friend from.
You see, if the judgment of the learned trial court is upheld, your learned friend will not be required to satisfy anything.
My lord, it was contributory negligence to the part. Mine is 60%. His is
Very well. If it is
40%.
upheld, that means whatever is there, whatever is paid, he has nothing to pay. Whatever you have deposited is nothing to deposit.
But if it is,
Yes.
if it is enhanced, then
If it is enhanced, then also
shared accordingly.
then definitely he has to
My
share
lord, I am
something.
grateful, and the pay and recover, my lord.
That's that also I shall see.
Because route permit was not seized, and it is against section 149 of the Motor Vehicles Act. My lord will kindly see.
Okay, if you want now, you want to cite, your learned friend has cited the main decisions, Sharola Verma and this
I'm relying also.
Pranay Shetty.
The route,
You have submitted your calculation. You
my lord,
want,
I will also.
you submit your calculation. I'm concluding the hearing. Yes, record an order.
My lord, your lordship, my lord, is allowing somebody to not to pay tax and then my lord make calculation.
Yes.
But my lord is, my lord, today in enhancement, my lord. Your lordship, my lord, what I could gather, your lordship, my lord, kindly correct me, my lord, if I'm wrong. My lord, is allowing somebody to get away with compensation part without paying tax.
My lord.
That I shall see what
Lordship,
can be
kindly,
done.
Kindly, my lordship.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. Hearing is concluded. Let this matter appear for judgment on 13/11/2025. Yes, give your calculation in course of the day.
I'm grateful, my lord.
I'm glad, my lord, for giving me a very patient hearing.
Okay, thank you.
Grateful to your lordship.
I'm grateful, my lord.
Rest of the matters after 2 p.m.
Today, one of the honorable
Yes,
judges-
3:15, the court has to rise. Anyway, I think before that it can be concluded.
খারাপ আমি জানি তুমি যেটা বললে
আবার
ওটা দাও না একটু দাদা। দাও, দাও, দাও।
এটা একটাই আছে, কি বলে দেবো? অন্য প্রিন্টারটা নিয়ে দাও।
কিন্তু কেউ তো কি বলবো যে মেয়ার অফিসার ফ্রম দ্য পার্ট
Calculation
যদি ভুল না শুনে থাকি লেভেল হতে খারাপ তুমি খারাপ
উইদাউট রেকর্ড আর এই সমস্ত
একটা জিনিস একটা জিনিস ভালো বলেছে যে আমি যে জানি
তো
জানি না। এটা ভালো বলে তুমি যে জানো না
এখানে তুমি এখানে উঠবে
এটা 3,000 টাকা হতো কিন্তু তাহলে ছেড়ে দিল তাই
কার্তিক বলেছে তোকে কোনোভাবেই হচ্ছে সুযোগ দেওয়া যাবে না।
সবচেয়ে বড় কথা বলি, কিছু মনে করবেন না, এই আপনারা যে ব্যাটনটা তুলে দেন না ওনার হাতে, আপনারা জানেন দিলেন দণ্ডটা তুলে দিল কেন আপনার নিজে পারতেন না কাজ
বলে 3,000 টাকা ধরতে
3,000 টাকা ধরতে বললো কেমন লাগলো দা
ওইটা চলা ভাড়াতে 3,000 টাকা ধরেছে।
ট্যাক্সটা খুব সুন্দর করেছে স্যার, মেঘনালি জানে তো কত জজমেন্ট ট্যাক্সের
তার মানে ট্যাক্সের ব্যাপারে
কোর্টে শুনুন, ট্যাক্সের প্রথম মামলা আমার সঙ্গে করেছে
জমা
প্যাসেঞ্জার
কোর্টে জমা
পাস চিকেন জমা করতে ঘটনা প্রথম আমি ট্যাক্স আমি শিখিয়েছি
কর না বাবা।
আমি বের করে নিয়েছি স্ক্রিনিং এর অবস্থা আপনি বলেন ভয়টা কোনো আপনি করতে পারবে না, বিয়ন্দার রেকর্ড যেতে পারবে।
I'm for the respondent.
I'm for the petition.
Yes. Yes, I'm reading out the operative portion. Hence, this application under Article 227 of the Constitution stands disposed. Order dated 1/9/2023 passed by Learned Civil Judge Junior Division Ghatal in TS 51 of 2019 is modified to the extent that the sale of bamboo bush as permitted shall be in the presence of special officers. Learned special officers shall fix the date and time of cutting bamboo bushes upon notice to the learned advocates for the parties and upon holding discussion with them in a meeting. Learned special officers shall be present when bamboo bushes will be cut and record the same in his minutes with enclosures of total number of bamboo bushes cut. The learned special officers shall also fix date of sale to be conducted in their presence. Upon the sale proceeds being collected by the plaintiffs, learned special officer shall prepare the accounts and submit report before the learned trial court within 2 weeks from the date of sale. Learned advocate for the defendants and learned advocate for the plaintiffs may remain present along with the plaintiffs when the bamboo bushes are cut and at the time of sale, but only one defendant may remain present on the particular dates. No other persons will be permitted to remain at the time of cutting the bamboo bushes. The police authority shall ensure that there is no breach of peace and shall submit report as directed by learned trial court. So and so are appointed as special officers with so and so remuneration. Upon submission of report, learned special officers shall stand discharged. The date for cutting bamboo bushes shall be fixed by learned special officers within 4 weeks from the date of communication of this order, and the report to be submitted by the learned special officers before the learned trial court must be within 2 weeks from the date of sale of bamboo bushes. It is hereby made clear that this order is confined to the sale of bamboo bushes of Devotra property and maintenance of accounts. Other issues with regard to merits of the suit are kept open to be decided by learned trial court. Disposed. ওইটা তো ইয়ে করতে হবে, চেম্বারে যাবে, হ্যাঁ, সই করে চেম্বারে সই করে আবার আপলোড করতে হবে।
Number 24.
I'm for the respondent insurer, Milord.
So your can one is there? Any application?
No, no application is there.
So matter is ready for hearing.
It's ready for hearing, the matter
So
not only the point of interest. Learned Tribunal passed an award, but the interest has not been awarded.
okay, well, let me see the award. So this is the ground of challenge.
Only Lord. Paper book there.
So you have challenged this award on the ground that interest was not awarded.
My
Total sum awarded is 13,50,000.
11 lakh.
No, no.
No, Lord.
Oh, you are paid for 13,50,000.
Milord, may I just shorten?
It was
Yes, yes.
Please,
Yes.
please.
my claim was on 30 lakhs, but I awarded 11 lakh something.
11 lakh is awarded, yes.
Milord, your lordship will kindly come to Milord, page number 22 of this paper book.
Page 22.
Lordship.
Yes.
Milord, this is the concluding portion of the award. Milord, ordering part. If I can read, Milord, the order, the last paragraph. The OP number 2, Cholamandalam, I am for the Cholamandalam, is directed to pay 11,72,400 to the petitioners by way of 2 account pay checks amounting to rupees 586,200 each to claimant, namely so and so, within 2 months from the date of this order. In default, the claimant petitioner will be entitled to get at the rate of 6% per annum interest on the above mentioned amount from the date of the judgment till realization. There were 2 errors. First of all, principal was directed to be paid without interest within 2 months. In case there is a default, my lord, by default clause, interest was levied upon me, and that to my lord from the date of judgment. My lord, as we were discussing in the morning, my lord, we were pointing it out to your lordship. My lord, under section 171, my lord, this is a well settled principle that interest, my lord, is liable to be paid by the insurance company from the date of filing of claim application. My lord, as per the usual practice of this court, my lord, for the last so many years, my lords are granting 6% interest. My lord, nobody is disputing that. We all are paying, my lord, 6%. So your lordship, my lord, in this case also, kindly against my, your lordship will kindly not make my my lord, the concession, my lord, record it. Your lordship will kindly grant them 6% interest.
So are there any authorities that the court has discretion not to award any interest?
No. But in extreme cases, maybe 1 out of 1,000. And
but if the principal amount is an exorbitant.
No, not on that. My lord, if insurance company can show with absolutely, my lord, absolutely correct evidence that the claimant had deliberately taken.
Yes, delayed the proceeding.
Delayed the proceeding, and it can be squarely, it's shown, my lord, without any doubt. In those cases, in some of those cases again, I would not say in all.
Yes.
My lord, in some of, that's what I said, 1 out of 1,000. In one of those cases, my lord, insurance, the honorable court said, since because of the claimant, the proceedings have been delayed, so let that for that delayed part, interest not to be paid. Otherwise, they are entitled for interest. Because, my lord, the principle is this compensation, whatever is the just compensation decided, they were entitled on the date of filing of claim application. That is what the principle Supreme Court said. You file the claim application, you should get the compensation on that day. Whatever the delay part is, insurance company kept that principal amount with itself. What insurance company did with this money? Insurance company, the money what it gets, it invests somewhere so that it can get, somebody, sometimes, the investment, is in the favor of the insurance company, sometimes it loses, but be that as it may, since principal amount was with insurance company, therefore, insurance company should pay interest on that principal to the claimant. This is the basic fundamental principle. On that basis, I say they are entitled for, I am arguing against myself, in this case, your lordship will kindly not record my concession.
So that is why, unless there are very exceptional cases.
Very exceptional cases, very exceptional. That is true.
I take it the argument of myself.
So I am arguing on his behalf. So, they are entitled for 6% interest from the date of filing of claim application till, the date the payment was made. So, lordship will kindly make an order.
Principal amount is already paid.
Yes, so your lordship will record that.
Deposited before learning terminal.
Yes.
Principal amount they have received, your lordship will kindly record that. Interest they have not got in view of this order. Your lordship will kindly direct my client to make payment of interest at the rate of 6% per annum from the date of filing of claim application till the date the amount was paid.
Within a period of 3 months.
I will deposit this interest part. Normally what happens, my lords are giving direction to the insurance company to deposit, if it is enhanced sum or whatever money is, before my lord's officer, Registrar General, High Court, Calcutta. Whatever the amount is, we will deposit that here. The claimants, upon due identification, Registrar General disburses that money through NEFT. Let me make it clear, lordship will kindly, because this would be a normal order in all cases. Registrar, all money in High Court to be deposited with Registrar General.
If the amount is enhanced or if the claim is passed by the High Court.
All money. If insurance company deposits pursuant to my lord's order, it would deposit it in the name of Registrar General, High Court, Calcutta. 1. Second, my lord, Registrar General will disburse the money to the claimants the way my lord directs, my lord, or the way the proportion is made in the tribunal upon identification through NEFT, because the Supreme Court order is there, directly into the bank account of the claimants. No, my lord, check handover, draft handover. So these two are, my lord, the basic ingredients, my lord, how the payment is to be made. So lordship, my lord, ask me to make calculation, deposit the money with the Registrar General within 6 weeks, 8 weeks.
Yes, you show me the provision, 171. Have that.
On the left top. This may has been interpreted by Supreme Court as shall.
Yes, record an order.
Grateful to your lordship.
Learned advocates for the parties are present. The claimants of MSCC case number 112. Sorry, the appellants before this court are the claimants in MSCC case number 112 of 2019 filed before the learned District Court of Dakshin Dinajpur and transferred to learned additional district judge, First Court, Balurghat, Dakshin Dinajpur. Stop. The appellant before this court, who are the claimants, is aggrieved by the award dated 22nd day of April 2024, passed by the learned trial court in MSCC trial court in awarding compensation to the claimants without awarding any interest from the date of filing till realization. Stop. By judgment and award dated 22nd day of April 2024, learned trial judge was pleased to dispose MACC case number 112 of 2019 on contest by observing and directing as follows. Quote, এই পাতাটা ইয়ে করে দেবেন, ঠিক আছে? এই যে page 7, হ্যাঁ? Page 7 ordering portion. As no appeal is preferred by the claimant with regard to the principal sum awarded, and the said amount has reached its finality and have been complied by the claimants, complied by the insurance company, there is no scope to go into the question of the quantum of awarded sum. However, upon perusal of the judgment and order dated 22nd day of April 2024, it appears that the learned judge has awarded compensation of rupees 11,72,400 to the petitioners and awarding interest at the rate of 6% per annum on the above mentioned amount from the date of this judgment till its realization. Stop. Heard learned advocates for the petitioner and learned advocate for the opposite party, learned advocate for the appellant and learned advocate for the respondent insurance company. Peruse the appeal file and materials on record. Upon hearing the learned advocates and upon considering the facts of the case, it is necessary to consider Section 171 of the Motor Vehicles Act 1988. Stop. Section 171 of the said statute provides that where any claims tribunal allows a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier than the date of making the claims, as it may be specified in that behalf. Stop. Although Section 171 provides the discretion to the learned tribunal dealing with the claim cases, but it is held in different judicial pronouncement that awarding of interest is the rule and refusal is the exception. Stop. Only in exceptional circumstances, the claims tribunal can refuse granting of interest. Stop. In the instant matter, the learned court has not assigned any reason as to why the interest is not awarded from the date of filing of the claim case till date of realization. Stop. Thus, this court is of the view that the award dated 22nd day of April 2024 passed by learned additional district judge, first court, Baludghat, Dakshin Dinajpur, in MSCC's case number 112 of 2019 should be modified. Hence, the judgment dated 22nd day of April 2024 passed in MSCC case number 112 of 2019 is modified to the extent that the respondent insurance company namely the Cholamandalam MS General Insurance Company Limited shall pay interest at the rate of 6% per annum from the date of filing of the claim case, being MACC case number 112 of 2019 till date.
No.
Till today.
No, till the date the actual awarded sum was paid. Because I paid the awarded sum, my lord.
Okay. Till the date when the awarded sum was paid to the claimants.
Lordship.
Such payments shall be made, such payments shall be deposited before the Registrar General, High Court, Calcutta, within a period of 6 weeks.
2 months from date.
8 weeks.
8 weeks from date.
Okay, within a period of 8 weeks from date.
Lordship.
The Registrar General, High Court, Calcutta, shall, upon production of necessary proof by the claimants, appellants, and their learned advocates, release the amount deposited by the insurance company.
Directly?
By making the said payment to the account of the claimants, appellants.
Grateful. My lord, third thing is, my lord, the claimants, my lord, the claim amount what they receive, my lord, they are supposed to pay, my lord, court fee stamp. My lord, the enhancement, whatever is made by your lordship, my lord, Registrar General to check whether the subsequent, my lord, court fee stamp has been made or not. Ad valorem court fee. Registrar General ke check korte dao.
Okay, the such payment shall be released upon compliance of all necessary formalities required under the law.
One thing, Lord.
Required.
Here, Lord, one thing, Lord. Here, Lord, your lordship is not enhancing the principal amount. Just granting interest.
My lord, your lordship.
Court fee is paid, Lord, on the.
Fees is based on the amount which is claimed.
My lord, here also have a look to the page 7.
No, if the amount is enhanced by the tribunal, okay.
If the amount is enhanced by your lordship.
No,
then
amount is enhanced means what? Suppose his claim amount, whatever he has claimed, that is amount is not enhanced in principle. Whatever amount he has claimed, that is 15 lakh or something.
13 lakh something.
13 lakh. So that is not enhanced.
No.
That is reduced.
My lord, court fee. My lord.
Unless it is a problem unless.
My
lord, your lordship come to page 22 of paper book.
I'll clarify. Let him submit. I'll clarify.
Okay, just such payment shall be released upon compliance of all necessary formalities.
Regarding payment of court fees.
Here court fees is not.
But if it is not required, it is not required.
They will, but it will delay the payment.
In the event,
it will delay
payment. Additional court fees is required, such court fees has to be paid.
My lord, I'm submitting this because, my lord, this would be a staple part of my lord's order in all cases.
All cases,
because, my lord, these three conditions.
Always when the principal amount which is claimed that is exceeded,
My lord,
definitely
my lord.
court fees has to be
May I
paid.
submit, my lord? May I submit?
Yes, yes, yes.
This statement will create problem to the my lord for release of the amount.
My lord, I claim,
They will ask me, bring certificate from trial court that you have paid.
Okay, okay, জায়গায় ওটা কেটে দিন। But amount shall be released upon compliance of all necessary legal formalities.
যেটা
my lord, I
enhance-
claim 15 lakhs. My lord, I am entitled to, my lord, proceed with the entire proceeding with the deficit fees of 10 rupees only. I'll do my entire case with 10 rupees.
That's why I am saying, Lord,
बोल रहे थे ना यार।
come to page 22. Court fee paid is correct. Court fee paid is correct in the tribunal.
Okay, that's all.
So, my lord, what my lord is thinking, my lord, that no, if I have claimed 15 lakhs, I would be paying upfront court fees on 15 lakhs. That is not the case. I will continue my entire proceeding with 10 rupees. And then award is passed for 12 lakhs, assuming, my lord.
You see, that means award.
My lord, let me finish.
Yes, award, whatever award is passed, he has paid the court fees,
My lord,
definitely.
my lord, I was coming to that. My
Yes.
lord, if I claim 15 lakhs, I'm not paying, my lord, court fee upfront for 15 lakhs. The 1%, my lord, is 15,000. I'm not paying that. I'll continue with 10. This is what happens in all cases, my lord. 7 except the exceptional ones. I got the award of 12 lakhs. I would be able to get the certified copy because I need to get the 12 lakhs rupees. I need to get the certified copy. Only if I pay, my lord, that, my lord, 1% court fee. So if my claim case is dismissed for any reason, I don't want to prefer an appeal, I will not pay anything. So, my lord, what my lord was thinking that I will be paying 1% upfront. No, that is not the case. I will continue and get my matter disposed of, and whatever is the sum awarded by the tribunal, then I will calculate and make payment of court fees. And if my lord, then 12 lakhs was awarded, claimant
No,
paid.
suppose the trial court would have awarded interest on that 11 lakh.
Lordship.
What was he required to pay the
No,
court fee?
No.
No, suppose instead of this appeal court,
Lordship.
the trial court
Awarded
has
11 lakhs.
awarded that interest. He would not have come here.
No.
So how much would he required to be paid?
My lord, whatever, my lord, 1% of the amount what he is getting, he will pay
Lord,
on that.
No, no.
Tribunal already held that court fee paid.
Whatever court fees is required to be paid by the before the trial court, that has to be paid.
That has to be paid.
Yes, if it is an enhanced amount, his enhanced court fees is to be paid. Now,
Now,
whatever
yes.
he has paid for, that is not awarded by the court. Lesser amount is awarded.
My lord.
Now, had the trial court awarded this interest, you would not have come to this court.
He would not
So,
have, lordship.
was he required to pay the additional court fees if the trial court would have awarded the interest?
In the,
That
not
is the
in this case.
question.
My
Now,
lord,
this
I'm
court is
saying for
doing what
other
the trial
cases.
court has not done.
my lord is saying, my lord, on interest amount, court fee is not to be paid.
That is what
Now,
I have.
mine
That is what I
similar
followed. You see, in the trial court
in
also.
other cases.
In trial court also,
Yes,
whenever
yes.
the amount was enhanced,
Yes,
there
yes,
was a
yes.
direction to pay. But when the principal amount was not enhanced, whatever it is interest was awarded, just to see the
Well,
court fees paid on the principal amount.
Is
claim,
correct or not?
correct
Is
or
cle-
not.
is-
That
is
much,
clear or
yes.
not? Yes,
It's
yes,
correct.
yes,
Court
yes.
fee paid is correct.
So, my lord, whenever my lord enhances any amount in High Court,
Yes,
on-
enhances,
in another
not
cases,
enhances.
My lord,
I understand.
I am doing the
Jumbling
needful
up.
what the trial court
I
ought to have done.
understand. Yes, your lordship is correct, my lord. Your lordship is correct.
Yes.
My lord, I was saying that this, my lord, would be a template so that in all cases, your lordship will not, my lord, forget, and my lord's officer will take these three
Yes, in
points.
trial courts also, many times you see, enhanced amount is awarded. By inadvertence, it is not recorded.
Yes,
So
yes,
again, when they go to collect this
Yes, yes.
certified
But my lord,
copy,
in High Court, there is no such provision. I deposit the enhanced sum, and then my lord's order is for disbursement through NEFT. So, my lord, they will not check up unless my lord's specific direction is
no,
there.
I have just specified that.
Lordship.
It should be relies upon compliance of all necessary
Lordship.
formalities. Okay, thank you.
Grateful to your lordship, my lord. I'm obliged.
Huh? No, রেজিস্ট্রারের কাছে তো ডিপার্টমেন্টই তো রেজিস্ট্রারের কাছে পাঠিয়ে দেবে। Proofs,
I'm not-
formalities, release the amount on compliance of all necessary formalities required under.
না আসেনি দেখছি
Check for now.
দরকার হবে না আমরা
Proof by the claimant, appellants, and their deposited by the insurance company.
And pay it directly to the bank account of the claimants.
similar either in equal shares or as per the
So whatever is there in the as per the trial courts, nothing.
that is to be said. That is to be said by your lordship.
My lord,
The share as indicated
By
in
the
in the award of the trial court, that shall remain.
My lord.
lordship, lordship.
Even if a lordship not said, they will not pay.
No,
It will
no.
make his task easier.
Yes.
We are suffering much for
ওই
this.
লাইনটা দশটা বললেন ওটা প্লিজ নোট করে নেবেন।
একটা হলো
In equal
straight away to the bank account of the claimants appellants, and the shares as awarded as directed by the learned trial court, that shall remain.
My lord.
As directed by the learned trial court, that shares shall remain.
My lord. Obliged to your lordship. Grateful to your lordship. My lord, 20, I'm not.
25.
25, my lord. I am for the appellant insurance company and the respondent.
Your application is scan 1.
My lord.
যাকে এটা লিস্টে আছে যখন
A stay was made absolute, my lord, and the
stay is
affidavit.
already made up.
Yes, affidavit of service was also filed.
So
And
take steps through the department.
No, my lord, the advocate has appeared, but since.
Then not today.
No, my lord, not this week, my lord, because.
Acha, not this week.
His son has gone under surgery, my lord.
Not this week.
Not this week.
26.
My lord, 26, I'm for the appellant. My lord, yesterday your lordship made it and not this week, my lord. 20.
Not this week or not today I made it.
My lord, yesterday my entry says not this week, perhaps.
Okay, not this week.
Not
Other
this
side is not here.
Lordship.
27.
My lord, 27 again is my appeal, my lord.
This can too.
My lord, Can 2 was a stay application. My lord, your lordship, my lord, I have pursuant to the order of this honorable court, my lord, I have secured entire awarded sum.
Yes.
I filed my affidavit of service. Your lordship will kindly make this stay absolute, and your lordship will kindly, my lord, through service to department.
Yes.
My lord, may I just also show, my lord, this challan which shows the deposit of the balance amount. এটা জজ সাহেবকে দিয়ে দিন চালানটা।
Yes, record an order. Learned advocate for the appellant is present, as the appellant insurance company has deposited the awarded sum in terms of order dated 30/7/2025. The judgment and order dated 11th day of March 2025 passed by learned additional district judge, 3rd Court, Paschim Medinipur, in MACC case number 195 of 2021 shall remain stayed till disposal of the appeal. Stop. The appellants shall take steps to serve notice of the appeal upon the respondents. Let the affidavit of service filed be kept with the record. Let this matter appear on 17/12/2025.
17 December.
Yes. So take steps in the meantime.
Yes. Through Talovana, my lord. And
Yes.
obliged to my lord. Take a Yes, thank you.
Item number 28.
28. Yes, you are for? Okay, 28, not today.
Lord, my lord has other determination also, first appeal, second appeal. Lordship will be taking up insurance matters all 5 days, my lord.
No, for this week, I am giving priority to the insurance matters.
Lordship.
Next week, I have to include other matters also.
My lord, in that case, my lord, if we can be given 1 day off or 2 days off, my lord.
In Friday, you see, part hard and assigned matters will be taken up after 12 p.m.
Up to 12?
Up to 12, some
First appeal, second appeal, my lord, those are there.
Yes, for some matters may be taken up, but after 12 or something like that, all part hard and assigned matters or original side matters which are part hard or assigned, those will be taken up.
So Friday, my lord, for insurance matters.
That can be done. That can be.
Your lordship will decide, my lord, so that my lord, at least we get 1 day off in between, so that it is easier for us
that
to
can be
prepare.
calculated. ইয়েতে কালকে কটা ম্যাটার আছে যেগুলো আছে কালকে তাহলে সেগুলো দিয়ে দেবেন, আজকে তো বেশি ম্যাটারই, এই মানে 6 তারিখে, হ্যাঁ, যেগুলো নট টুডে হলো, আর হ্যাঁ এগুলো দিয়ে দিন আর কি, আরো এই তো ফাইল তো বেশি কিছু ম্যাটার নেই, অন্তত 50-55টা যাতে থাকে। হ্যাঁ 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 হ্যাঁ, ফাইলগুলো আসলে তাহলে এগুলো ঢুকিয়ে দেবেন।
My lord, this was the calculation my learned friend made, my lord, in that matter which was taken up heard by your
হ্যাঁ,
lordship
ওই
in the first
যেটা সিএভি ম্যাটারটা আছে না, ওই ক্যালকুলেশন
item
একটু ঢুকিয়ে দেবেন।
22, 23, my lord.
হ্যাঁ, সিএভি ম্যাটার ওই ক্যালকুলেশন শিট
Item 22 and 23, my lord, she has made the calculation. My lord.
কি কোথায় চেম্বারে চলে গেছে নাকি?
Okay, extremely grateful, your lordship.